This is a continuation of a hearing that we started about 2 weeks ago. It's June 29th, and are the parties here? Could they please identify themselves for the record?
Good evening, Madam Chairwoman. My name is Hamza Chowdhury on behalf of the appellant.
Thank you. Could you spell your last name for me?
Sure. Last name is spelled Chauary.
Thank you.
Thank you.
Todd Romano on behalf of the town. I apologize.
Randall Souza, S-O-U-Z-A, for a number of abutters and neighbors, including David Stewart, Ty Levine, Norm Whitehead, Gregory Klinker, Jonathan Klinker, Susan Miguel, David Rickerby, and a group called Stop the Quarry LLC, comprised of other individuals in the neighborhood.
Thank you. My reading of the transcript when we last met, Mr. Romano had given his arguments, and Mr. Souza was cut off by our time limitations of 10 o'clock. Mr. Parks, for the appellant, had not decided whether or not he was going to rest. So is that a good place to start?
Yes, Madam Chairwoman. At your convenience, I'd like the opportunity to address the board, for the board to consider additional legal argument, and then at that point, if it's okay with the board and you, Madam Chairwoman, we can proceed with the rest.
Okay, so you're finished with putting on your case, and it's just final arguments you want to make?
Not final arguments. I have additional legal arguments for you to consider.
Okay. Do you want to do that now, or do you want to do it at the end of the presentation?
I can do it now. I can do it later. It's completely up to you, Madam Chairwoman.
I think, why don't we hear from Mr. Souza first?
Of course. Thank you.
There's a lot of echo on these mics.
Thank you, members of the board. I was very close to the end last time of argument. I have affidavits, and I'm sure there are members of the public who will speak, but we're not at that stage yet, correct? The most telling thing will be David Rickerby, who happens to be an attorney, but he's here pro se as a witness. He lives at 60 April Lane, has submitted a presentation to the board. I circulated that to everybody. The most telling thing, I think, is he will walk through the aerials that show exactly what happened here, and one of them happens to be up. And I think once he does that, the board will see that the so-called gravel area, which is Field 5, was filled in decades ago, and there was never any quarrying activity where it's happening now by Bud Way. And that's clear from the aerials. He'll also show you all of the real estate transactions that the Jeromes entered into, selling residential lots all around the farm, where now some very nice high-end residential homes have been built. He'll also walk through the grassland easements and the other filings that were made to get preferred tax status on this property, while also representing that it was being used purely for farming and that no earth removal operations, quarrying, or granite removal was happening there. So combined with that and the affidavits and testimony of people who've lived in the area, who are going to say that nothing like this has ever occurred for some people going back to 30 years that they've lived there, will clearly support a finding, I would proffer to the board, that if there ever was a legal nonconforming use, and you're not deciding that today, But assuming there was a legal nonconforming use, that it was long ago abandoned, and the ordinance says 1 year of no activity is an abandonment. I think you can also clearly find, and I think Mr. Romano will put in evidence of this, that there's been an expansion way beyond what the ordinance would allow. And that goes back to the Carty case, which has a 3-part test, but one of the things is there must be an objective intent to dig in other areas of the parcel. An owner can't just say, 20 years from now, I think I might go over there and dig. There has to be some kind of objective intent, and the aerials will show that the area by Bud Way, which is now unfortunately a granite quarry, was never mined, ever, until really Betty Jerome died, and it happened weeks after that. So we did submit a brief on abandonment. I think that's entirely within this board's jurisdiction to address abandonment. The Breakers case in Newport clearly stands for the proposition that while you may not decide whether a legal nonconforming use exists, you certainly can adduce evidence and facts to determine whether it's been abandoned or expanded. And after this board's determination on these appeals, if that goes to the Superior Court under the Administrative Procedures Act, it's just on the record here. So this is where you're going to make factual determinations of what's happened at this site. The last thing I would say is Betty Jerome's affidavit, I assume, is part of the record. I don't know if it was
Yes.
marked. Okay. Obviously, she's passed. She's not subject to cross-examination. Your rules of procedure say that you have the discretion to give that limited weight if the person's not available here. I will say that a couple of people who I've submitted affidavits on behalf of, they're not here this evening. They had travel outside the country that was already committed to. And I understand that Stephen Jerome, whom I don't represent, but I submitted his affidavit as a non-party witness, he works second shift and he is not here tonight. But you'll hear through those affidavits and through live testimony how the activity that's happened there is drastically different than anything that was done in the 70s. That's all I really have, unless you have questions about the law issues. I don't know if the board permits cross-examination or if questions go through the chair. What is your procedure relative to witnesses who do testify live?
Well, our procedure, this is a public hearing, so witnesses can testify and there is cross-examination.
Okay. The only thing I would say to that is, I don't know if you want to get into it now, the regulations, let me just grab it, not the regulations, the zoning board's rules of procedure somewhat address this issue. So first of all, under the Cola Giovanni case, which goes back to 1960, our Rhode Island Supreme Court has steadfastly held that before a zoning board, an applicant or an objector does not have a constitutional right to cross-examination. Now, the procedures of the Tiverton Zoning Board, I think it's at 7V, and I have to grab it over there, do say that for hearings on special use permits and variances, cross-examination is allowed. It does not mention appeals of building official orders. So I would make that distinction and argue, of course, it's entirely within the board's discretion, but I would argue that there is no right to cross-examination in an appeal of a building official order. And the Supreme Court has been clear for decades that there's no constitutional right to cross-examination. So I would just say if cross-examination is allowed, and I entered my appearance on the record, then on behalf of neighbors, I would want the opportunity to cross-examine as well.
Sure. I mean, this is, a public hearing, so whoever wants to be heard can be heard. And the board will give the testimony or the exhibits the weight that it feels that is justified. But I'm not going to deprive opposing counsel the opportunity of asking cross-examination of your witnesses.
I understand. Now, I noticed, I think last time there was a recusal and an alternate member sat as the fifth. Is that not true?
No.
Okay, so we have four?
In fact, I'm glad that you brought that up because in my haste to get going, I neglected to put on the record who was up here and deciding the case. George Alzabak is sitting. He was here last time. He's a regular voting member. I'm Lisa Kishite. I'm the chair. I was here the last time and a regular voting member. To my right is David Collins. He's our vice chair and was here on a previous occasion. And Jay Jackson is also a regular member, and was here before and will be sitting tonight as well. And Sally Ferrer is our stenographer.
And one Tara.
And Tara Ferreira.
Madam Chairwoman, just a brief note for the record, may I be heard?
Sure.
Thank you, Madam Chairwoman. I believe my colleague, Josh Parks, covered this last time, but out of abundance of caution, Madam Chairwoman, and for the record, we respectfully object to the materials that have been submitted by Mr. Souza and the objectors. As Mr. Souza indicated, I believe at least 3 out of 5, if not all of them, are not here for cross-examination. So there is no way for us to...
I understand. And I believe me, as a former criminal defense lawyer, I'm sensitive to those issues.
Thank you, Madam Chairwoman.
We're considering Betty Jerome's affidavit, and she's not subject to cross-examination. Yeah. The strict rules of evidence don't apply here.
Of course, yes.
And so we're going to let just about everything in, and if I'm wrong, then someone can tell me I'm wrong later.
Of course, Madam Chairwoman. I just wanted to note that for the record.
Absolutely. He objected the last time as well.
Absolutely. And I will also respectfully and officially object for the record the presentation that includes 288 pages, a lot of which is irrelevant to the questions and the determinations for the board to be made.
We'll take that one step by step.
Thank you.
Are you going to present any evidence? Any testimony?
I'm not going to be presenting any testimony,
Okay.
just legal argument.
Todd, do you want to present any testimony?
Yes, yes, please. And it's mostly to create a record where I will present to the zoning official. I will be as brief and expedient as I can. John? Dispensing with a lot of the formalities. State your name, please.
John Hoyle Jr.,
Your position, please.
Building and Zoning Official, Town of Tiverton.
We can't, I don't think we
Share
can
a
hear him.
Thank you.
Mr. Hoyle, how long have you been a zoning and building official?
2 years for the Town of Tiverton, almost 25 years in total from the state of Rhode Island.
Let's get right to the point. Are you familiar with 536 Highland Road Rear?
Yes, I am.
Why are you familiar
Excuse
with
me, can the people in the back hear this? No. We're going to have to do something so people can hear it.
It's just too much echo too. There's too much feedback. Much feedback.
Thank you for your help.
I think we have an extra mic right here on the stage. There's an extra mic right there. At the end. Sorry.
Thank you. comfortable testifying standing up, or do you want to sit down?
Standing is fine.
Okay.
Mr. Hoyle, we were discussing why you were familiar with 536 Highland Road Rear.
Around December of last year, it came to our attention that there was some noise emanating from that property.
John, do you have an opinion to a reasonable degree of certainty in your capacity as a zoning official of whether the current earth removal, quarrying, or mining activity, whatever it is, at 536 Highland Road Rear is within the area of excavated surface
Madam Chairwoman,
as of 2001?
I apologize for interrupting. Madam Chairwoman, I know the rules of evidence don't apply, but for the record, I'm going to want a running objection to
He objected to leading questions.
Thank you.
Do you have an opinion?
Please repeat, just so I can be clear.
Yeah, and Todd, can you speak up too, because I'm having a hard time hearing you.
I shall. Mr. Hoyle, do you have an opinion to a reasonable degree of certainty in your capacity as a zoning official of whether the current earth removal, quarrying, or mining activity, whatever it is, at 536 Highland Road Rear, is within the area of excavated surface as of 2001?
It is not.
You do have an opinion, then?
I do have an opinion
And what is that opinion?
that it is outside that area that was identified in the 2001 aerial photographs.
Okay. What do you base that opinion on?
My review of the aerial photographs going historically back as far as we could, as well as my observations from being on the site on several occasions.
Is it based on anything else? Did you receive any complaints, for example?
We have numerous complaints from neighbors.
Did you conduct a search of your office or the town hall offices?
For other documentation relating to this, I have.
Okay. So is your opinion based on all of those things that we just discussed?
They are.
All right. So you said you've been to the site, correct?
I have.
Have you kept a log of your visits to the site?
I have.
Do you know generally how many times you've been to the site?
Or at least 20.
Describe for us your observations, starting with what you first observed on your first occasion and how, if at all, it has changed since then.
My first visit to the site in December was with the fire marshal based upon the complaints of noise, and we did observe that
And
there
was
was...
this, I'm sorry, 2022?
December 2022, that's right.
Thank you.
Yeah, and I observed some heavy machinery, a large excavator, and a rock crushing machine at the site. At that day, it was not in operation, but there was evidence that some mining and other operations were happening at that time.
Did you subsequently visit the site?
Yes, I did.
On those subsequent visits, did you see any excavation, quarrying, mining activity occurring?
Yes, I did.
Okay, can you describe that?
I did witness on a number of occasions the actual machines running and trucks being loaded with the excavator.
What was the area of excavated surface that you observed in December 2022? And let me try that again. You had an observation of excavated area in December 2022?
That's right.
Did you subsequently see excavated area on subsequent visits?
I did.
All right. Did the area of excavated surface change over the course of those visits?
It did.
How did it change between December 2022 and your last visit?
It grew significantly.
When was your last visit?
This past Friday, 23rd? 23rd,
Okay.
June 23rd.
All right. Describe for us, if you can, how the area of surface excavation or excavation changed.
As I said, it grew significantly.
But where? Where did it start? Where did it end, if you can do that? And
If
up
we-
on the wall, we've put the 2023 spring aerial GIS map. Do you agree?
I do.
Will that help you describe the area of excavation?
It would.
Okay, go ahead and do your best.
So the yellow outline of the entire parcel, there's that piece that comes in from Bud Way, that little hammerhead, for instance. The excavation begins just north of that, where you can see on the evidence of the GIS map what looks like a trail or a clearing, and it is continuing to come down over toward Main Road and then back around that hammerhead.
Now, hold on. So we're all clear. You're kind of starting in the center.
In the center.
Off of the hammerhead lot, is that correct?
That's correct.
Then you come down towards the bottom of the image?
That's right, south.
Okay, south. And And did it go anywhere else? Did it go east?
It went east
Okay,
in a semicircular pattern.
okay. Your observation of excavated surface area, did it extend, I'll call it north of the Hammerhead lot?
No, it did not.
And can you just tell us again what equipment you've seen at that parcel?
Numerous large dump trucks, a large excavator, a rock crushing machine.
Have you seen each of those pieces of equipment in operation?
I have.
And can you describe kind of for us the sounds while you're on site?
It's a noisy operation.
Okay. Why do you classify it as noisy?
I would think anybody that can hear would consider it to be noisy. I don't have a decibel meter, but it's certainly above, you'd have to yell in order to be heard if you were anywhere near that equipment while it's being operated.
Have you been in other parts of town and heard equipment from this site operating?
There are occasions I can hear it from the front door of my office,
Your office at Town Hall?
at Town Hall.
And do you know approximately how far that is from the site?
I would estimate a quarter of a mile, perhaps.
Your office has received complaints, you've indicated, is that correct?
Numerous.
And what were some of those complaints about?
About the noise,
Anything else?
the vehicular traffic.
Anything else?
Some of the individuals had expressed concerns about the runoff that's coming down from the driveway toward what they call the gut, the wetland area at the bottom of the road.
Okay. Anything else, like a vibration complaint?
Vibrations they have complained about.
While you were on site and saw equipment operating, could you feel vibrations?
I could, when I was up close to the machine while I was operating, yes.
Okay. And mostly for the record, you have in fact reviewed all of the GIS photographs concerning this site that are available on the town's website, is that correct?
All those that are available, yes.
The only one that's not available, we agree, is the 2002 GIS map for whatever reason.
For whatever reason, 2002, correct.
And can you describe what you saw for earthwork or excavation work, quarrying, mining, over the course of those GIS maps from, I believe the first one was 1939 through the present?
It would be easiest to compare the last year and a half to 2 years as far as seeing from the GIS photographs significant additional clearing of areas where the mining operation is occurring.
Okay. For purposes of your cease and desist orders, did you focus on aerials just from 1997 to present?
No, I went as far back as we possibly could.
Okay. But you just told us that you saw significant change most recently, is that correct?
That is correct, most recently.
And you've attached GIS photographs or aerials to your cease and desist orders?
I did.
Again, you searched your office and caused your office to be searched for materials relevant to the earth removal, quarrying, and mining activity, correct?
I did.
This included looking for surveys, for contour plans, for bonds, for plans to cover ground that, or to be planted, and for special use permits, is that correct?
In my office as well as planning in the town clerk's office, that is correct.
Did you find anything in that exhaustive search?
Did not.
Did you find anything concerning 536 Highland Road Rear that's pertinent to tonight's inquiry in that search?
Well, a former cease and desist order by one of my predecessors.
Mr. Hoyle, take a look at the document I've presented to you. Do you recognize that, sir?
Yes, I do.
Do you want to mark it?
Let's give it to him.
Mr. Hoyle, what is the document that you're looking at, sir?
It's a cease and desist order dated November 29, 1989.
Who is it directed to?
Edward and Betty Jerome.
Does it identify a property?
It does.
What property?
Well, it's addressed to the property at 536 Highland Road.
Okay, and what does it indicate is to be done?
Cease and desist.
Cease and desist what, Mr. Hoyle?
I hereby, this is the letter reads, I hereby order you to cease and desist from removal of any gravel on this site immediately.
In your search of the records in your office, did you find an appeal of this cease and desist order?
I did not.
Okay, that's the right answer.
Oh, okay. Sorry.
We gonna marking this? Marking?
Mark of the exhibit?
Please. You can do it as one if you'd like.
Sally, do you?
Town 1.
Down one.
We didn't swear the witness. I'm sorry. Can we swear the witness?
I do.
Do you understand, Mr. Hoyle, that the testimony you were about to give and gave already?
And gave already.
Thank you.
Madam Chairman, for the record, I'm going to object.
I understand.
The witness was not sworn in ever, and...
You want to go through the questions all over again?
I'm not running the show for the town, but with all due respect, retroactive swearing in has never worked before. So I just wanted to put that on the record.
Well, we could, want to go through the questions again?
Under the lenient rules of evidency that would be applicable here, I think
Okay.
we're fine.
Proceed at your peril, Mr. Romano.
Thank you very much.
And the witness is subject to cross-examination anyway, so any prejudice you have will be protected. Good.
Mr. Hoyle, while inquiring with the different departments in the town about this property, were you presented with any other evidence regarding the use or regarding excavation, quarrying, and mining at this property?
Yes, I was.
Let me show you two documents, sir.
Thank you.
Mr. Hoyle, do you recognize the documents that I've presented to you, sir?
Yes, I do.
And
So
we mark
this
it?
down too?
Town 2, please.
Town 2 will be the Natural Heritage Area Investigation dated November 2017. Town 3 will be at Ecosystem Solutions, Inc., dated October 19, 2007. Any objection?
What's the second?
Objection.
Mr. Hoyle, is it your understanding that these reports were prepared for Mr. Chase in relation to a project that he was presenting to the planning board?
Yes.
Can you identify on either Exhibit 2 or 3 why these documents were important to you?
Why the documents weren't what?
Important to him,
Why they were important?
correct.
Okay.
It does make reference to that, based on this report, that it claims that it's also the site of a historic gravel pit in the center of the property, which is now mostly reforested.
All right, hold on, Mr. Hoyle. You are starting to read from the second paragraph, and it looks like the third sentence.
Yes, I'm sorry. Second paragraph, third sentence.
And what does that sentence say, please?
It is also the site of a historic gravel pit in the center of the property, in which is now mostly reforested. more or less commensurate with the UD soil map unit shown in Figure 2. The gravel pit appears to have been in operation starting as early as the 1950s and ending as late as the 1980s.
And where did you get this document from?
This was found in the planning office
Okay.
in conjunction with a project that Mr. Chase was proposing. Exhibit 2, which is the Natural Heritage Area report. Why is that one important to you, sir?
Page 3, in the brief property description, it indicates the last and second to the last sentences. It is also the site of a historic gravel pit in the center of the property, which is now mostly reforested. The gravel pit appears to have been in operation starting as early as the 1950s and ending in the late 1980s. An invasive sapling and tree called Hercules Club is common and mostly occurring as colonies in previously disturbed parts of the property.
Does that last sentence,
What page are we on, Todd?
Page 3.
first paragraph? The fact that it's noted that there's Hercules Club regrowing, does that mean anything to you?
It would indicate to me that no additional quarrying had been occurring since his assumption of the operation ceasing in the 1980s.
And this was a document submitted by Mr. Chase
It was
in 2017, did you say?
That's correct.
And Mr. Hoyle, both those reports are concerning 536 Highland Road Rear, is that correct?
That's correct.
Now, Exhibit 3, you read a sentence there, it is more or less commensurate with the UD soil map unit shown in Figure 2, is that correct?
That's correct.
I've put up on the screen the Figure 2 from that report. Do you see that, sir?
I do.
Do you see where it says the UD section?
I do.
And the UD is kind of outlined. I don't know if the board can see that, but I can't do much better. I'm sorry. You good? Mr. Hoyle, given where the UD section is identified on Figure 2, and as being identified by Ecosystem Solutions, Inc. as the site of the former gravel pit, does that match up with the area that you saw being excavated, quarried, or mined?
It does not.
Can you describe to us, just for clarity, where in relation to the UD area you saw excavation, quarrying, or mining?
If everybody can read the map, this section that is delineated as RP, and again, you can clearly see that what I describe as the hammerhead coming off the Bud Way. So it would be significantly south of the UD area.
Mr. Hoyle, is earth removal as defined by the Code of Ordinances in Chapter 38, Article 3, a use allowed by right in any zone in the town of Tiverton?
It is not.
What must someone do to do any earth removal?
They would have to get a special exception or other dispensation from either the council or the zoning board or whatever governing body.
They'd have to get a permit under Chapter 38,
They would have
correct?
to get a permit. They would.
All right. Otherwise, correct me if I'm wrong, pursuant to the Zoning Ordinance, Article 4, Section 15A, loam stripping for purposes of removal off-site is prohibited. Is that correct?
That is correct.
Did you observe any loam or topsoil or any type of, dirt being removed at the property?
I saw an abundance of all kinds of materials being removed from the property.
And did you see what was being loaded into the trucks leaving the property?
That was a processed material.
Does Highland Ridge,
It was the material that came out of the rock crusher after it was dug out of the ground.
does Highland Ridge Farm have an earth removal license to your knowledge?
They do not,
Has Highland Ridge Farm ever had an earth removal license?
not to my knowledge.
Is quarrying or mining an allowed use by right in any zone in the town of Tiverton?
It is not.
Is it prohibited by Zoning Ordinance Article 4, Section 15M, as in marry?
That's the section. It is, yes.
And that's specifically quarrying of or mining for sand, gravel, rocks, or minerals, correct?
That's correct.
And obviously, that's unless it's a legal pre-existing non-conforming use, correct?
That is correct.
Right. That also assumes that that pre-existing use has not been abandoned, correct?
It has been in operation legally, right? That is correct.
All right.
Not abandoned.
If it is a legal non-conforming use, the town of Tiverton allows it to expand up to 25% beyond the area of excavated surface existing on June 4, 2001, pursuant to Article 14, Section 6A of the Zoning Ordinance, correct?
Correct.
Beyond the 25% expansion requires a special use permit pursuant to Article 14, Section 6C, is that correct?
That is correct.
Do you have any objective evidence that the Jeromes intended to continue any type of quarrying or mining activity at this site?
I have no evidence of that.
Do you have any objective evidence of what areas of 536 Highland Road Rear the Jeromes at any time ever intended on quarrying or mining?
I don't.
We've talked some about complaints from neighbors and your observations of noise and truck traffic, correct?
Correct.
Do you have an opinion to a reasonable degree of certainty in your capacity as a zoning official of whether the current earth removal, quarrying, mining activity, whatever it is that's occurring at 536 Highland Road, is substantially different from and creates an adverse impact on the surrounding neighborhood as compared to the operations conducted by the Jeromes prior to June 4, 2001?
I have no idea what the Jeromes were operating at the time. I wasn't here, but what I did witness is detrimental to the area and is not permitted by the zoning ordinance.
Do you have any evidence that they were conducting any type of quarrying, mining, earth removal activities as of June 4, 2001?
No, I don't.
All right. So any activity would then be an increase, right?
It would?
And based on what you've heard, seen, you would consider those activities to be adverse to the community today?
Yes, I would.
And that opinion is based on everything that we've discussed so far this evening, is that correct?
That's correct.
To include your observations of the equipment,
Observation of equipment?
what you could hear from town hall,
That's right.
and again, the complaints of the neighbors, correct?
Correct.
That's all I have at this time, Mr. Hoyle.
Thank you.
Nope, stay.
Oh, sorry. Of all the aerial photographs that you viewed from the beginning of time, was there ever any objective evidence of quarrying on these properties before 2001 from the maps?
I could not discern any quarrying activities prior to that.
And how about from 2001 to 2017?
There didn't appear to be any significant changes whatsoever in that time frame.
I don't have any questions. Thank you. Does any member of the board have any questions? Jay? No. You may inquire.
Thank you, Madam Chairwoman. Good evening, Mr. Hoyle. Good evening. Mr. Hoyle, I wanted to talk a little bit about your direct testimony. Do you have any certifications that would give you any expertise in interpreting historic aerials?
Repeat that. I want to make sure I give you a correct answer on that.
Of course. Do you have any certifications that give you expertise in interpreting historic aerials?
I am recognized by the state of Rhode Island as a certified building and zoning official, and I think part of that includes being able to discern what is and is not certain applicable cases. I didn't realize that there was any course of study to be an expert in reading aerial photographs, but my history using them type of information goes back more than 25 years.
So, sir, you would agree that given that you weren't aware that there were any certifications available, that you do not hold any certifications for interpreting historic aerials, correct?
I would have to agree with that assessment.
Thank you. Mr. Hoyle, did you take any decibel readings of the noise that you testified about?
I did not, but we have copies from the police department.
Okay, are you aware that the municipal court in Tiverton threw out those noise ordinance violations?
I'm aware there's an issue with that, yes.
Okay, thank you. Do you have any expertise in interpreting plant life?
No, I don't.
Okay. You had previously testified about the Hercules plant in that report, is that correct?
I'm sorry, I'm having trouble hearing you.
I'll do better, thank you. Are you aware, so you testified about the Hercules plant in that report that you had mentioned on direct examination, correct?
I read the report that was supposedly conducted by an expert in plants.
Okay. Are you aware that that Hercules plant was purposely planted by RIDEM?
I was not.
Okay. One moment. Now, Madam Chairwoman, I have the report that I believe has been marked as an exhibit. I'm looking at this particular page. It's not marked. It's a RIGIS topographic map dated October 19th, 2017.
What exhibit are you referring to?
I believe this is Town Exhibit 3 or 4.
We haven't gotten to 4 yet.
So I think it's 3. It's a part of the report that is the natural from Ecosystem
Oh,
Solutions.
it's 3. That's Town 3. That's Town 3.
Okay, thank
So
you.
What page?
So Town 3, I am, one moment. If you count from the back and you go to page 6, it's the back of page 6. Yeah, it's this right here.
Figure 1?
Yes, figure 1.
Everyone got that? Oh, this one. Hold on. Everyone have it?
Yep.
Jay, this different report. Dave, this report. You get the wrong one, Dave. It's the other report.
The other report.
It's attached.
Yeah, unflip it. There you go. That's the back of that. There you go.
That's it.
Oh, it's the back of that.
Figure 1.
There you go. Okay.
Sorry, go ahead.
Thank you, Mr. Solicitor. So on this particular page, I'm pointing to the word that is named, there's a word and it says quarry. Would you agree with that?
I would agree it says that.
Okay.
Where do you see that?
In the middle right, top right,
Top right.
See it there?
inside the red.
Oh. Sorry, thank you.
And what is the date of this particular map?
December 19th, 2017.
Thank you. Now, Mr. Hoyle, when you served your cease and desist notices, did you certify cause for imminent peril to life or property?
I would have to go back and review. There were several documents that we prepared as part of the cease and desist orders.
So sitting here today, you don't know what is contained within your own cease and desist letters?
I didn't memorize it, no.
Okay. Would it be surprising you to know that you did not certify that there's any imminent peril to life or property?
Would it surprise me that I did not?
Yes?
No, it wouldn't surprise me.
Okay, thank you. Mr. Hoyle, do you agree that Highland Ridge constitutes a lawful, pre-existing, non-conforming use for extractive industries?
I do not agree with that.
Okay. So in that light, you agree that this board now needs to make a determination of whether or not there is a pre-existing, non-conforming use. Isn't that correct?
That's, yeah, sustained.
I want to point everyone to the cease and desist notices. I'm looking at the cease and desist notice dated March 22nd, 2023.
They all are dated that date.
All right.
They all have different subtitles.
If you look at the heading, they're in a category, they're in parentheses, it tells
Oh,
special
okay.
use permit, so if you.
Thank you,
refer-
sir.
yeah.
So the one I'm looking at says earth removal and quarrying/mining. Candidly, I think it's all the same. So if you want to go to any single one of them,
Let's go here.
Well, they're not all the same, but go ahead.
the language that I'm going to quote is.
Okay.
Okay. Now, Mr. Hoyle, I'm going to read from this. If you could follow along at the bottom of page 1 on to page 2, let me know if you agree with what I'm saying. So, do you agree that this is a cease and desist notice that was issued by your office?
Yes, I do.
And it was issued against Highland Ridge?
Highland Ridge Farm LLC.
All right, thank you. Now, at the bottom of the page, the last sentence starts, this cease and desist order is not intended to, and it does not change the town's position and arguments in those matters, and specifically does not change the town's position or waive its argument that your claimed uses are illegal and not pre-existing and non-conforming use. Did I read that correctly?
Yes, you did.
All right, and that lines up with your testimony that you just gave me a minute ago, correct?
It did.
All right, now moving on. It says, instead, assuming arguendo that your earth removal and or quarrying activities are pre-existing non-conforming uses, you have impermissibly expanded those quarrying activities to areas to which there's no objective evidence. Did I read that correctly?
You did.
Now, you
Whoa,
test...
whoa, whoa, whoa,
Wait-
hold on.
wait a minute.
I'm
That-
sorry, can you read that? I'm sorry, you're on page
I
2.
thought you were talking about the earth removal license.
He is.
Madam Chairwoman, I'm reading the second paragraph on page 2.
Go back to the subtitle on the front page.
You're reading part of the paragraph of page 2.
Yeah.
Yeah, earth removal and quarrying mining.
Okay.
Where you going?
I want to make sure they're on the same document.
Yeah.
I'm sorry, go ahead.
Okay. So for purposes of your cease and desist, you are assuming that there is a pre-existing non-conforming use, correct?
Yes.
Okay, and that actually contradicts your earlier testimony that there is not a pre-existing non-conforming use,
That's
correct?
not what he said.
That's based on his,
Madam Chairwoman, I apologize. I believe his previous testimony, and with respect to the board, was that he agrees that there is not a pre-existing non-conforming use. And the following line says, assuming arguendo, there is a pre-existing non-conforming
Which we're
use.
required to assume under the case law. I think your question's confusing.
Okay. This is going to serve the foundation for a later legal argument, so I appreciate a little leeway, and I understand your point, Madam Chairwoman.
How
So,
much leeway?
very little.
Very none. Just straight up fact.
Just let him testify, go ahead. Go ahead. It's just important that we build a record, as you know, so we're just, go ahead.
That's exactly what I'm trying to do,
I know
Mr.
you
Solicitor.
know. Go ahead.
So these cease and desist orders are based on, quote, assuming arguendo that your earth removal and or quarrying activities are pre-existing non-conforming uses, correct?
that's a continuation of the original part of this, in saying that even if you thought that you had a pre-existing non-conforming use that you could continue to use, you have gone beyond the 25%, which is allowable without the special use permit.
But that's the basis for the rest of the cease and desist, correct?
This one, for this one?
Thank you. Now, Mr. Hoyle, did you have any discussions with town officials prior to issuing the cease and desists?
Yes, I did.
Who did you discuss this matter with?
My town administrator and the town solicitor's office, and we don't have a town planner any longer, but
Okay, and who at the town did you speak with? Who's the
Christopher
manager?
Carter, who was the town administrator,
Okay, and who from the solicitor's office?
Michael Marcello, and Todd Romano.
Okay. And I don't want to get into attorney-client privilege, but so were you in the same room as Mr. Marsalo and Mr. Romano?
At which point, on several occasions, we do actually meet in person. On other occasions, we communicate by telephone and by emails.
Okay, so just to be, so the record is clear, prior to issuing these cease and desist letters, you had in-person meetings with Mr. Romano and Mr. Marcello, correct?
That's correct. Oh, I'm sorry. Okay.
And for the record, Mr. Romano just objected and said he objects on the basis of attorney-client.
On the grounds of privilege?
Correct.
Sustained.
Okay, thank you. Just to be clear, I wasn't asking about the content. I was asking
understand.
who was there. So I understand they're claiming
You've
attorney.
established that his two lawyers were there, so.
Thank you. And to be clear, Mr. Hoyle, you've exchanged emails with both Mr. Romano and Mr. Marcello on the emails, correct?
Sustained.
Okay.
Communications with his lawyers are not proper subject of cross-examination.
Understood. Again, Madam Chairwoman, I'm laying the ground for the legal argument I'm about to give at the end.
I further object because it's not a clear question. We advise, clear, we communicate about numerous items, and that question was open-ended.
Well,
I can re-ask it.
the questions, whatever was discussed or what meetings you had with counsel are not going to be gone into.
Of course, just to make the record clear, I'm not asking about what was discussed. I'm just asking about the existence of those communications. So just for the record, and again, if that my question is sustained on the objection, I respect that.
Okay.
But I just want to make sure the record is clear
The
about what
record's
I'm
clear.
asking, Madam Chair.
It's sustained.
Okay, thank you. I have no further questions at this time. Thank you.
Thank you. Would you like to inquire?
Mr. Hoyle, what?
One second, on the mic, please. Thank you.
What is the area zoned that 536 Highland Rear is in?
Residential, I believe it's R40.
And is Highland Ridge Farm LLC maintaining a house there, as far as you could see?
Not on that particular property.
So the activity that is happening at that property, is it fair to say would either have to be illegal activity or a prior existing legal nonconforming use?
It would have to meet, yes.
And your cease and desists are based on the presumption that if it is a legal nonconforming use, you still found issues with that use at present time?
We contend it is not pre-existing non-conforming legally.
But assuming, for the sake of argument, that it is a legal nonconforming use, did you issue cease and desist orders in any event?
Yes, we did.
Okay. That's all I have.
I have a question.
Mr. Hoyle?
Yes. I just want to clarify something, and I've seen it in the paper and everything, but I just want to make sure I'm getting it and everybody else getting it. Even if we assume, according to your cease and desist, I want to understand you, even if we assume he has not existing non-conforming, they went beyond the 25% or whatever percentage they're allowed to, so they're already in violation, even if they have one.
That was the basis for that last
I
document.
just want to put that, make sure we're clear on that. Thank you. Thank you.
Thank you.
Anything else, Mr. Romano?
That's all I have, thank you.
Okay. Mr. Souza, would you like to present witnesses?
So first of all, we submitted affidavits that we circulated to everybody. So the first order of business is either for me to read them into the record or to have them marked as exhibits.
You can do both. if you want.
Well,
Let's
tell
mark,
me what
let's
you-
mark them to begin.
How many copies do you need up there? Well,
We have a copy.
Yeah, we have copies of
but the
everything.
steno needs one, right, to mark? Okay, so let's, do we call it objectors or public?
Call it objectors, A, a 1.
I'm doing numbers or letters?
We're going to do numbers.
Okay.
No, objectors. Right, town 4.
Well, this would
We're
be
going to do
different.
objectors 1.
So then I'll ask that the affidavit of Ty Levine be objectors Exhibit 1. The affidavit of Stephen Jerome be objectors Exhibit 2. The affidavit of Susan Miguel be objectors Exhibit 3. The affidavit of Gregory Clinker be objectors Exhibit 4. And the affidavit of David Stewart be objectors Exhibit 5.
You've provided these to council already?
Yes.
And then, Madam Chair, again, for the record, we object to the reading and/or the entry of these affidavits into the record. I know you've already ruled. I also, in addition, for your consideration, some of these affidavits contain hearsay. And that's yet another reason to question their validity.
Well,
Thank you.
we're accepting them.
Understood. Thank you.
Okay.
Now, I believe Mr. Levine is not here. He's traveling outside the country. Again, I don't know if you want me to read it. Mr. Levine resides at 17 April Lane. He's lived there since September 2020 and has lived there continuously.
You know what, to save time, we've admitted
Yeah.
them as exhibits, so they speak for themselves.
I'm just saying where they live. And Mr. Jerome, Stephen Jerome, is the son of Ed and Betty Jerome. I've given his affidavit. I think it's a very telling affidavit. He currently lives at 66 Bud Way, which is right next to the Hammerhead lot that you saw in the projection. It's immediately to the north, I believe. And his affidavit includes his time as a child living with his parents, as well as since he's moved to Bud Way. Susan Miguel lives at 38 April Lane. She's also not available tonight. She's, I think, in Arizona. She is married to Gregory Clinker, which is Exhibit 4. That's their husband and wife residing at 38 April Lane. Their son, Jonathan, is here. He will testify live. David Stewart is here, I believe, and he lives at 593 Highland Road. I'll let him come up. My plan was really to have him speak as a member of the public and not really do a direct. So David, if you could come up.
I do.
Stuart, here's your affidavit. If you just want to read it and add commentary as you see fit, since you're here in person.
Sure. David Stewart, 593 Highland Road, Tiverton, being
Read
sworn.
slowly, please.
Okay, sorry. Being sworn hereby deposed state as follows. I am legal age and sign this affidavit voluntarily under oath. All statements in this affidavit are based upon my personal, where am I now? Based upon my personal knowledge, I have owned the property at 593 Highland since 1986 and have lived there continuously since 1987. My driveway is located approximately 100 yards south of driveway 536 Highland Road Rear, a Highland Ridge Farm property. From my home and yard, I can directly view 610 Highland Road, which Ed and Betty Jerome resided there from 1963 until their deaths in 2018 and 2022, respectively. I was familiar with and spoke frequently with both Ed and Betty. With their approval, I walked or rode my bike on the property of Highland Ridge Farm from time to time during this period. As such, I was afforded an opportunity to directly observe the activities the Jeromes are undertaking at the farm. Over the course of those years, at no time did I ever personally witness or hear any noise or activity associated with mining, quarrying, or blasting at 536 Highland Road Rear. Either while I was on the property or in the neighborhood or while I was in my own home. The only time I ever witnessed or spoke to the Jeromes regarding any non-farm related earth removal at 536 Highland Road Rear was when I sold an abutting lot that I own next to my current home at 593 Highland Road to Joseph Derber. Mr. Derber wanted to build a full basement, but he had to do some blasting to achieve this. Excuse me. The company from Maine did the blasting in 2019, and a trucking firm from Freetown, Massachusetts was...
What year was that?
2009.
I think it said 19.
Excuse me, sorry, thank you. 2009. A trucking firm from Freetown, Massachusetts was trucking the rocks and debris somewhere near Freetown. Ed Jerome approached the contractor and told him if they placed the rocks and debris from the blasting on his land, he would take care of disposing of the materials. To my knowledge, subsequent blasting and excavation debris from 593 Road was taken and delivered to Highland Ridge Farm per Ed Jerome's request. Other than this one exception that occurred in 2009, the Jeromes conducted no granite sales, quarrying activities, gravel production, or other earth removal operations at Highland Farm, which observable, visual, or auditory from my perspective as a very close neighbor for 36 years.
Stuart, could you just describe what conditions are like there now from your property? As far as any noise or traffic or anything?
Soon after Betty died, the end of August, lots of noises and activities started to create. Then trucks from Potter Trucking Company, I believe out of Little Compton, started coming and going. And it just started going sometimes at 8 in the morning until 4. It wasn't every day. Some days it was 5 days a week. Sometimes it was only a couple days a week. But, and that just, so I started asking around what was going on, and everybody else started hearing it. Even Louise Durfee called me up and said, David, what is going on? And she lives up past the town hall, I believe, a good quarter of a mile away. And it was, that's when I started talking to the neighbors, the people on April Lane, my next door neighbor where the quarry was done, when Jerome took the rocks. And it was loud. I work at home quite a bit with my windows closed. I could hear it. It sounded like a train going over a trestle all the time. I mean, really loud.
What did you observe those trucks to be carrying that came and went?
Gravel. They were and they were big trucks. And I was concerned because the little bridge that connects around the gut, that these trucks were either pushing the limit or whatever. And they were, then the dust. There was a neighbor who lives right behind me. He's got a black pickup truck. And he said, oh, the dust was, evident. And so that dust is deadly. It's not stuff you want to be breathing. And I mean, the noise, it was obnoxious.
What kind of trucks are those that you're talking about?
He had dump trucks, but he also had the big trucks with, 40-footers with separate, trailers.
Those flatbeds?
No, they're all 10-wheelers. I'm not a trucker, so I don't know. But they were big trucks, and they were loaded. And sometimes my neighbor, who has even a better view, he saw 15 trucks a day coming in and out of there.
What do you do for a living?
Real estate broker.
And could you describe briefly the neighborhood that's around 536 Highland?
Yeah, exactly. There's between a radius of 1,000 feet from, is this thing still working?
Yep.
1,000 feet radius, there are 153 homes with an assessed value of $64 million. And being a real estate broker, that's definitely going to affect the values of those homes, consequently affect the town's budget and the whole town, because nobody wants to live next to a quarry. It's a nightmare. And, you know, it's just it's a real problem.
Did you sense any of this quarrying activity occurring before Betty Jerome died?
No. And it ironically started within days. And I used to see Betty almost every, I walked my dog for 30 years, not the same dog for 30 years, but I've walked dogs that around the gut almost every day, year round, and I'd see Betty, you know, feeding the ducks, and we'd talk, and this, that, and the other, and I used to see Ed when he was alive all the time, and there was, nothing happened until the end of August.
Of what year?
2000, just this past August, August 2020.
So it's been about, what, 10 months this has been going on?
Yeah.
I have no further questions. I don't know if you have anything more to tell the board.
Yes.
Mr. Stewart, when you first began living in this neighborhood in '87, did you observe any truck traffic coming or going from 536?
None.
Any blasting noise?
None.
Were you aware of any commercial activity taking place on the Jerome's farm?
No.
And is the same true for the 90s
Correct.
and 2000s?
There was, the only activity I saw was in 2009 when Ed worked a deal with the truckers from Freetown to take the debris and whatever from the lot next to mine, because this guy wanted a full basement and they blasted, and Ed took it, and like I say, I don't know what the arrangement was, but those are the only time I saw any activity like that.
And when you went for your bike rides or walks, what was going on the property? Was farming going on?
Yeah, Ed had, you know, he was haying and he was doing stuff, you know, he was doing much more related, you had some animals, you know, it was very low key. You know, Ed's main thing, from what I gather, was real estate, selling the lots. But, you know, the farm, you know, Ed was, he died at late 80s. I mean, he was, you know.
So he was taking it easy.
Yeah,
Yeah.
no, I mean, he'd stop and would talk and this and that. He was just kind of casual, you know, he wasn't running a business there.
And when you would take your walks, would you go all through the farm?
Pretty much, you know, the area between closer to April Lane was all fine. You know, it's grassy, and there's a pond there. We go there. There's a waterfall. We used to go out to the waterfall. Then you'd wander up, and you could go around, you know, Budway, and you know, there's no special route. Just, you know, it was nice because the topography is very interesting. It's you know, a lot of, you know, farmland. There's hills. There's a lake or a pond. So it was just, you know, but there was no sign of any commercial activity.
No gravel pits?
No.
Okay. That's all I have. You have a question?
I know you've been living there for a long time. We want to move the town together. As you build your house and other houses grew and big houses and people spend a lot of money to come and retire in Tiverton or live in Tiverton and build these houses, do you think, as of today, your quality of life, living in that house, taking a nap, walking that dog, and I'm not going to speak about your neighbor, but if you spoke to your neighbors, and I'm sure you know the answer, do you think today's quality of life is the same it is 2 years ago, 3 years ago?
No, it's dramatically changed. I mean, I moved to Tiverton. I used to live in Newport. I moved to Tiverton because I found a very nice piece of land. It was, you know, 4 acres when I bought it. And it's peaceful. I mean, it's very serene. I mean, we overlook the gut. I mean, it's beautiful. And when you hear this boom, 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 boom noise, it's it's like I say, it's got to devalue the home's values. I mean, it has to.
One more question. I know you knew Jerome, and I met him a few times as I have a business down the street. The question I had, do you ever see them would have sold that property thinking they want to destroy the neighborhood of people they've known
No,
for years and people they lived next to?
no. Betty loved that area, and she loved the whole,
Yes.
the whole ambience of it. I mean, she definitely would have not have sold it to an operation like this.
Thank you. I appreciate it.
So, I guess it would be cross, and then, cross, and then I think Mr. Rickerby would be.
Good evening, Mr. Stewart.
Hi.
All right, I want to go to the first page of your affidavit, paragraph 3. I'm going to read that to you and let me know if you agree with what it says. It says, 3, I have owned my property at 593 Highland Road since 1986 and have lived there continuously since 1987. Did I read that correctly?
You did.
All right, go to paragraph 5.
Yeah.
It says, quote, from my home and yard, I can directly view the house at 610 Highland Road, at which Ed and Betty Jerome resided from 1963 until their deaths in 2018 and 2022 respectively. Did I read that correctly?
Yes, you did.
How do you know that Ed and Betty Jerome resided from 1963 until their deaths?
Because I know the Jerome family. I know that they lived there then because, I mean, I got to know them, you know. I mean, having lived there 37 years, and I'm a real estate broker. I actually at one time was talking to Betty about potential if she sold the house, I'd be interested in possibly buying the house. So look at the town records. Actually, I got that off the town records too.
Okay, so is it fair to say that Mr. and Mrs. Jerome told you that they've lived there since 1963?
Why would they have to tell me if it's a fact?
How do you know that they lived there since 1963?
The town records. I mean, I know they lived there since 1960.
Okay. Now, Mr. Stewart, paragraph 7, I'm going to read that to you. It says, quote, over the course of those years, at no time did I ever personally witness or hear any noise or activity associated with mining, quarrying, and or blasting at 536 Highland Road Rear, either while I was on the property or in the neighborhood or while I was at my own home. Did I read that correctly?
Yes.
All right. Would it surprise you to know that your testimony contradicts the affidavit of Mr. Steve Jerome?
No, I have not read his, but this is my observations, okay? And I said that in the beginning.
Okay, got
And
it.
I took an oath to say these are my observations.
Got it. So it would or would not surprise you?
What different? Yeah, I mean, this is my.
Madam Chairwoman, it just goes to the problematic nature of these affidavits. They contradict one another. And if you'd like, I can.
We'll get to that.
Thank
You
you.
can see that. They're both on the record.
And last but not least, the second page, Mr. Stewart, full first line, starting right there, says, quote, let me know if you agree with what I'm reading. Ed Jerome approached the contractor and told him if they placed the rocks and the debris from blasting on his land, he would take care of disposing of the materials. Did I read that correctly?
You did.
How do you know that?
Because I saw them, and there's videos that show there in 2009, show exactly where the rocks were placed.
Okay.
So when you get around to seeing the pictures, you'll see it.
All right,
And
so-
they were not there, and you can also see in the pictures, the house that's right below mine, right on the corner of Bridgeport Road and Highland Road, where the work was being done. So they took them from the driveway and they drove them up to Ed's.
So it's your testimony here today, sir, that you saw Ed Jerome approach the contractor and tell him certain things?
Ed hung around there all the time. He'd come up there and talk. I mean, Ed loved to talk. So he came up, yeah.
Okay, so you saw that conversation.
I was there. I saw it and witnessed it.
All right, no further. One last question. Are you a real estate appraiser, Mr. Stewart?
No, I'm a real estate broker.
Okay, so you...
For 25 years, and I do a lot of work in Tiverton.
Got it. Thank you.
You're welcome.
Any other questions? You're excused. Thank you.
You're welcome.
Mr. Souza?
David Rickerby of 60 April Lane, who is my client, will testify next. And he has a PowerPoint presentation. It was bound at Staples, the old ring binders, and distributed to the board and sent to council. It is lengthy, but I would point out that over 150 pages of it is an appendix that is just there for convenience in case people want to look at any document that's referred to in it. The actual slides are about 97 pages, about a third of which are aerial photographs.
We're going to mark this, right?
Yes, so do you have a binder?
We have them, don't we?
Does the Seto need a binder
Oh.
for that? Okay, so this will be Objector 6, is that right? The binder will be
6.
Objector 6. I think they're all set, but
Just one, just one.
The board has it, just for the
give
record.
one to the Seto. Yeah, we're gonna move the mic to where. Oh,
Technology, you know.
Mr. Rickerby is way more technically proficient than I am.
But I know nothing about land use. Or that was my goal 1 year ago today. I do. Members of the board, Madam Chairwoman, thank you very much. I should not be here right now. I moved into Tiverton exactly 1 year ago today, my wife reminded me. I moved here intending to never do anything like this, and certainly not to slaughter the trees required to create this book. However, my life became a nightmare over the fall, over the last 6 months of my sort of living there. And the reason for which I bought my house, I run a small law firm, a technology law firm, I do intellectual property law. The reason for which I bought my house became untenable. I can no longer do what I do, which is work from home. So this is a long book, and I wanted to, as I tried to make sense of what was going on and what I was hearing from various people, and as I talked to my neighbors, I accumulated a bunch of information. As I accumulated all that information and I just put it in chronological order to make sense for myself, I thought, two things are true. One, this really helps tell the story and figure out what's going on, and the Board of Zoning should see this. And two, if any other lawyer did this or the town's lawyers did this, it would cost us all an arm and a leg. So since I happen to have a unique set of skills, I thought I would put together a binder of the factual evidence. But I'm also going to try and fly through this. I'm happy to stop for questions, but I'm going to try and fly through this because, man, if I could do this all night long, and there's lots of people here who are more affected than I am, who have been affected by this longer than I have, who need a chance to speak. So, ready? All right, so I live at 60 April Lane. I live right up there. I'm not a direct abutter. If I can get my mouse to show you. Well, nope, my mouse cursor's not going to show, but so I'm about 1,300 feet from the quarry site. I'm going to fly through this, but I bought my house on April Lane to work from home as a lawyer. Because I am a lawyer, I did actually search the land records before I put in an offer on the house and note that I was moving next to Highland Ridge Farms. So I did what any lawyer would do and say, okay, what's Highland Ridge Farms? Am I going to be, moving next to a nuisance? And I pulled up the public record right there, that one. That was my first foray into the public records database. That's from the Secretary of State. That's the Highland Ridge Farms LLC record that says they are a farming operation, hay crops, and a forestry operation, logging. Does not identify them as a quarry. Relying based on that, I said, okay, I am going to buy this house. So I did. I'm going to fly through this, but in my office, while I sit and read these wonderfully exciting cases and IP things, it measures. I have a little sound meter that I happen to own as a gag a while ago. So I have lots of decibel readings, and it measures between 55 and 65 decibels, depending on the season and exactly what's going on. And as David said, it's like this. And now I'm trying to read case law. Well, that's going on. All right. So I'm trying to actually, make sense of this exciting legal stuff, well, that's going on for 4 to 8 hours a day. And again, like David said, it's random, so it's sort of like you don't ever know if you're going to lose that day or if you're going to schedule that conference call and have that noise. So I basically can't work from home, and there's some stuff in there about that. Now, I did add here, we hired Randy because I know when I shouldn't be involved, but I added here a couple of slides about the law, and in the materials, I included just the case law that Adler Pollack cited in their memo. And I did that because when I read their memo, I was like, oh man, I'm in a bad way. And then I read the cases, and Jonathan is a law student who is working with me on this, and he actually summed it up better than me. He's like, I read the cases that they cited, and I started to read them, and I was like, wait, I think this is the wrong case. This doesn't say at all what the memo says. So I thought that the board would benefit from having the full text of the cases, and in my slides, I highlighted a couple of items there, but again, I don't want to talk about the law. That's up to you guys. I do want to say that they said repeatedly that they said, I think in their memo, that this is the town of Carty, the Carty case. Well, the Carty case was an existing quarry where trucks were going in and out, and the question was whether or not you could expand that use to land that had not yet been quarried. That was the Carty case, and they gave you this quote from the Carty case, but they neglect to actually quote the key part of the Carty case, which is they said it's a 3-part test, which includes that the person who wants to expand the use must prove that the area they desire to excavate was clearly intended to be excavated as measured by objective manifestations and not subjective intent. So it can't just be I intended to do this, that there was some objective manifestation. And so that was part of my digging into the public record. Where is the objective manifestation that I should have found to know that this was a quarry I was moving next to? And so that gets us to the heart of my presentation, which is I just took the pictures from both Google Earth and the GIS website, and next to the pictures, I put them in chronological order, and next to them, I included where I found what I thought were applicable records. I included those records, and again, and oftentimes to make this presentation a little bit shorter, I included the full body of the records in the appendix for you guys if you wanted to look at it, and just a quick throw to it from here. So I have no certification in aerial photography. I don't allege today that I am, can do that, but I do think that these aerial photographs tell a story. We start in 1939, where Betty Jerome says that in her affidavit that they had been quarrying this land for 100 years, and you don't see any sign of any quarrying or digging in this 1939 photo. Now, in the 2015 grassland easement, which we'll talk about, which the Jerome signed, they say that you should look at the 1939 aerial photograph to see that this was traditionally used as a hay farm. And this does look to me like a hay farm, but again, I'm not certified in that. You go to 1951, 52, again, we're talking about our sort of 100-year quarry here. I don't see it, but maybe it's there. Then you get to 1962, and this, for me, was an eye-opener, and I am probably against the advice of my counsel, just giving you everything, which is that there is a land record that I found, one of the only ones, that the Jerome's family, Catherine Jerome, Ed's mother, leased to the ATR Construction Company from 1954 to 1957 and 1959 to 1964. She leased land for quarrying. That land with the yellow star, which I'm going to call Field 5 for a reason. That is, I wouldn't argue that it's not a historic quarry in the 50s. I also point out for you right now, and we'll get back to it repeatedly, it's something that I didn't realize until I did this little process, but I point out to you the little green circle, that hammer, as it was called, which is lot 130. All right? So because I'm speeding through this, so you now go from 62, and I'm going to go all the way forward to 89. But what you see, and this isn't great to see it up here, you really need to see it on a computer screen, and there is an electronic version of this if you need it. But what you really see is the quarrying stops, the land gets regrown. Maybe it's cow pasture, maybe it's quarry. I'm not an expert. But I'm going to fast forward to 88 because that is when the public records reveal something else. And what the public records reveal in 88 is that the Jeromes found a new and apparently more profitable business than earth removal, and that was real estate. The Jeromes sold approximately 42 lots after 1988 out of their farm. 42 lots. They built a whole new residential neighborhood, substantially different character to the neighborhood than existed when this was a quarry in 1950, right? So they built 42 lots in that era. Now, I found this, and I thought, and it's sort of like, and as you look at the overheads, you see the sort of the green regrowing and overtaking the previous stripped sites, and you see it really start to regrow after 88. But then I found out that, lo and behold, in 1989, there's a cease and desist letter telling them to stop. So maybe that's another reason that they decided to stop taking any earth off the property and move to real estate, But that's there. Now, as to the question of abandonment, I count, and we'll talk about this in a second, I count 17 different points at which you could find an abandonment in the property records here. And that's being generous. That's just because I'm only counting like the development of Budway as one abandonment instead of each of the separate houses. If we counted each of the houses that they sold as a potentially, non-conforming use that would be adverse to a gravel quarry, then we'd be up at like 50 or 60 potential findings of abandonment. But so I count 17, and in my mind, this first one is really here in 1989. I mean, the request for the gravel permit early on is its own issue. It indicates they knew they needed a permit. But right here, they were told to cease and desist, and as far as I know, they ceased and they desisted. And it's never been appealed. And so to some extent, although I think it's very important that the board does have their finding on the 5 cease and desist letters, and there's an existing cease and desist letter on the file. What Mr. Chase got was whatever rights Ed Jerome had. Ed Jerome's rights were terminated in 1989. Everything after this is gravy. So we're going to move forward. I'll go through again, we move forward in 95. You see the land start to, again, you're seeing two things in the pictures. You're seeing the greenery grow. You're seeing Budway now really start to emerge. I think I did not include in here my oversight in terms of providing you with pretty pictures, but the actual Budway development plan, which is, clear, big subdivision approved by the town, which I've also been told is another thing that would often be a grounds for an abandonment, is with no reservation of any quarrying right on it. One of the reasons that I included so much materials in the appendix was because there were so many Jerome real estate transactions, and none of them said anything about a quarry or a reserved right of any sort. And it's really hard to prove the negative, so I can only do it by sheer weight of materials that I took my time and looked at. And it's like, you sold this guy a house. You didn't say you're buying a house next to a quarry. In fact, when they sold Budway, they specifically, from the very first paperwork for Budway, they have this beautiful, because it's, if you're a lawyer, handwritten last-minute addendum for the first sale of the Budway property, where it says, and by the way, for all of these properties, you can't have farm animals. You can only use it for a single-family residential use. They burdened all of that Budway land with single-use, single-family residential easements, trying to build a nice residential neighborhood. So again, I'm going to fly forward. I couldn't find, I heard them saying that there's a 2001 aerial photo. That's beyond my Google foo. I could only find, sort of moving from 97 to 2003, that obviously hits the 2001 date, which is important. What you see in this between 97 and 2003 is just this steady move to greenery, no sort of indication, again, to my unprofessional eye as a member of the public, but no indication that there's any quarrying, no construction roads, no stripped land, none of that. There's a fun story about July 2003 where you will see in the Stephen Jerome affidavit, he testified that he was only aware of 2 times after 1971. I think I'm maybe misstating this, but he said that in the mid-2000s, the early 2000s, Ed Jerome got into a dispute with the developer of the William Barton Reserve, and so momentarily tried to restart gravel quarrying, and that the developer of the William Barton Reserve got a cease and desist order at that point as well, although I was unable to find a copy of that. So moving forward, it just gets greener and greener. And I move now, as it's filling in. There's Dave Stewart's pile of rocks in 2009. There, the yellow arrow, and this is one in terms of telling the whole truth. I put in here that it was at 593. The yellow arrow is at 583 Highland Road. But you see the yellow arrow there in July of 2008 is just green land. In April of 2009, you see the new house and you see the pile of rocks. So it is really sort of fun how the aerial photos match up with the stories that have been coming out. The rocks are, it's hard to see here, the rocks are under the electrical conduit. So it's hard to see there, but that's where they are. But they're sort of being, and I call it, in some of my things, I call it the storage field because that's where he stored the rocks in my mind. So that's April 2009, but we move forward to April 2010, where I get to sort of the next set of public records that I think are really interesting. And that is, this is the first year that our tax records for the town of Tiverton are online electronically. And if I was a little bit more devoted and I wanted to do another 100 pages, I would have gone to town hall and looked before that. But in 2010, the Jeromes received the farmland tax abatement credit, certified by the Department, the DEM. And this is what the DEM website says right now about the farmland tax abatement credit. It says, land used for commercial removal of soil, gravel, stone, or other minerals, or land used for farm stands, parking lots, and display areas is not eligible for inclusion in the program. I checked the regulations. The regulations going back to 2002 state that if you're found to be doing these things on the land, the farmland classification will be revoked. And in the appendices, I provided each and every one of the certifications, and you can see there's a pretty substantial tax benefit to being farmland. The appendices, I apologize, they're not in the books because I do like trees a little. But so there is a tax benefit to being farmland, a significant one, as Mr. Chase knows, since he also applied for and received the farmland tax exemption, as did Highland Ridge Farms. So 2010 to 2016, the Jeromes apply for and receive a tax credit that requires that they not mine granite on the land. Then in 2017 and 2018, Thomas Chase personally owns the land, applies for and receives a tax credit that requires that he may not remove granite from the land. And in 2000, well, I should say, to be precise, that is revocable if he removes granite from the land. They have to catch him. And in 2022, Highland Ridge Farms applies for and receives that tax credit. So 2010, and the story is, there was a little online fight about this, and I'm like, were the Jeromes committing tax fraud? No. The Jeromes were doing a smart thing. They were selling real estate. They were getting a tax credit, and they weren't mining gravel. It's a pretty easy story. So 2011, 12, still no new signs of excavation, no new signs of excavation. Again, I know everybody in the back is like, well, that's a beautiful picture. It's hard to see here. 2014, it's all becoming overgrown. 2015. 2015 is the next big event here. This is the grassland easement, because the Jeromes did know how to monetize their land. So in 2015, the Jeromes sold the federal government a easement right that prohibited them and any future property owner from undertaking a whole bunch of different activities on the land. including parking your dump truck and your skid steer on Field 5, Mr. Chase. The grassland easement is the only other place that I found a mention of the quarry in the land records. And there, we'll hit it, it says that Field 5, where the original thing that I would say, in my non-expert opinion, might have been a quarry was, is part of a, quote, reclaimed quarry. So I provide here for you the fact that a reclaimed quarry, reclaimed means to bring wasteland or land formerly underwater under cultivation. So they presented to the federal government and received $82,500 for presenting to the federal government the idea that this was a reclaimed quarry. I provide the full text of the grassland easement for you because it's got lots of fun little things in it. It's got, the fact that the government is inquiring about the whole property and not just the part where the easement was granted. It has a statement that the land is, the current operation consists of 2 beef cows. There have been as many as 20 on the property. The current land owner will be keeping approximately 2 cows annually on the grazing land. And then we get to Field 5. And in Field 5, we see now that they have actually sold the former quarry to the federal government, or they've sold the development and mining rights of it, where that yellow star is. So Field 5, which was the historic quarry here, is now actually protected by a federal grassland easement. There's a bunch of stuff in here about the property being suitable for birds that need big undisturbed areas. But I, again, leave that for your review.
Our stenographer needs a break. Oh. So I'm sorry to interrupt your presentation.
Oh, I don't want you to get, no, absolutely not.
Also slow it, take it, slow it down.
All right, I'm just trying to get through it all.
I appreciate it, but I think we need to, we've been going at this for almost 2 hours.
Okay,
so,
I'm happy to take a break.
Hold your thought.
I can do that.
We'll be back in 10 minutes. Thank you. We're back in session now. Please take your seats. Please continue where you left off.
Sure. All right. Our fearless
I think you were talking about the grassland conservation easement.
I was just completing the grassland conservation easement. Our fearless adventurers, we are now at 2015 still, and the trouble with Lot 130, and why I brought Lot 130 to your attention and how it solved a whole bunch of mysteries for me as someone looking at the land use records. So Lot 130 is the Hammerhead lot. It's up there with that green dot on it. The picture you're looking at here is Ed Jerome's plan to do one last real estate development for 5 lots. And the problem with Lot 130 is that there is an easement that needs to be converted into a public street. And oddly, the people who live in Lot 130 did not want that easement converted into a public street. What happened then was an exchange of, oops, oh, my mouse is like I need a break. An exchange of nasty letters between lawyers, my favorite kind, and a lawsuit wherein the Jeromes sued the owners of Lot 130. I don't have all of the details. I did not have time to go into what went on in these transactions. I know that at some point in these transactions, or I have been told, that Mr. Chase came in as a realtor to represent the Jeromes, and that the Jeromes were in some sort of negotiation with the land trust. I have seen files from the land trust discussing their sort of review of the property to buy it. But what happened is, instead of selling it to the land trust, Mr. Chase bought the property from the Jeromes, and in this lawsuit, the Jeromes were dismissed, and Mr. Chase became the party suing the people that own Lot 130. Now, I'm not a litigator. This is still listed as an active litigation in the court system, so I assume it is still active, but it's ancient. So there's an active litigation between Mr. Chase and the people who own the Hammerhead lot. In 2016, just keeping up with our story, Mr. Chase purchases the land from the Jeromes for $400,000. And they take back a mortgage. They provide a mortgage to him of $350,000, so they continue to have a financial interest at that point. Now we enter into a period in looking at the overheads where, to my eye, what we see is a lot of nothing. The forests continue to grow in 16, 17, and 18, while the Jeromes and Mr. Chase pursue a number of land development plans with which you all are probably more familiar than I. I don't know. My counsel is asking me if this relates to the report that you just got from 2017 showing the reclaimed gravel pit, and yes, I believe that is part of the filings for one of those transactions, but I haven't seen that report and I didn't get into those records. So we go 16 to 18, and in this time period, again, Mr. Chase is filing for the farmland exemption on the property. He will later, and I do not question his reasons, so I should just say, so 17, 18, if my memory serves me, and you can double check me in the appendices, my voluminous appendices. In 17 and 18, it will be farmland. In 18 and 19, if I'm correct, it will be listed as residential land vacant. Not commercial land vacant, but residential land vacant before it switches back to being farmland. In any event, in 2019, the planning board will finally decide that none of these subdivisions are going forward because there is not proper access to the land to be developed. And I included here, I actually put my little green bullet at the wrong place. It really is at the end of this page where the decision says that because there is a dispute between the proposed servient estate owner and the dominant estate owner regarding whether there is an easement available for the proposed subdivision on the dominant estate. And so basically they turned him down because he couldn't use the driveway of lot 130. At that point, a number of things happen in the record. We see the formation of Highland Ridge Farms, LLC, which is formed for hay farming purposes and is always listed for hay farming purposes. And we see Mr. Chase obtain an affidavit from Miss Betty Jerome in April of 2019, which I have not been able to find a public record of existing prior to Betty's death when he sued the town and made that affidavit public. I obviously have not searched every single public record that might be in. But he obtained that affidavit, created Highland Ridge Farms for hay farming purposes, and transferred the land from himself personally to Highland Ridge Farms. We see again, it's a hay farm. Getting right to the end of this, now we will see the beginning of activity, especially in this spring 2019 picture. You can see there's some stuff on the record about him cutting down a whole bunch of trees, and you can see that the trees are cut. I am told other people who are here tonight can testify by this, right on the borders of the various people who objected to his real estate developments. You can see those cuts here, and some of those people are here in the audience wishing to speak. But so we go forward, we see the area that is now the quarry develop. It is not the traditional area that is the quarry. You can look at these pictures at your leisure, and you will see that the quarry continues to grow and grow and grow until the summer of 22, when Betty Jerome dies. And at that point, so there is something going on the land. And for my April Lane neighbors and I, and now having met my neighbors, the people who are in Budway have been dealing with this problem far longer than we have. It was not until Betty died and he started pile driving and then gravel crushing all day long that the people on April Lane and Highland Road became aware of it. The people on Budway have a very different opinion of how long this has been going on. So Betty dies. Her affidavit becomes public, and he sues the town. There is this massive fish kill that we can't tell you came from the quarry, but last time Mr. Parks wanted to say that nobody has alleged that any environmental damage ever occurred. So I enter into the record that there was a massive fish kill right down that became, sort of a highlight of the town listserv right after Mr. Chase amped up his activity. And that brings us to the present. And in the present, if you look at this, you see lot 130 there underneath the electrical conduit, and you'll see the quarry, and I really wish that you could see this well, because I don't know if they're in the audience tonight, but the Mellows who live in lot 130 deserve sympathy and friendship from all of us, because this is operated as close to their property line as it could be. And then, just as a final statement, it is now for sale and this was the day I saw this listing, was the day we got together as a group and hired Mr. Souza. It is now for sale for $9.5 million. As an ongoing quarry, I personally, as a lawyer, I wonder if, as a realtor, if he bought it for $400,000 from his own clients. But that's not for me to think about. All I know is that your portable gravel permit that he alleges, that 1971 or 1974 gravel permit issued to another property, is apparently worth $9.1 million, which is amazing. And that brings me to the end of my presentation. I have some grandstanding and pontificating here, which you don't need to hear. There is a list of the appendices here. I didn't print them out. I will maintain for at least the next 30 days a full copy of this available at that Dropbox link for anybody who is here who wants a copy of this presentation. Come see me and you will get a copy. I am available for questions.
I think you've covered a lot of ground. Thank you. I don't have any questions. Does anyone else?
Well done.
Thank you. Cross-examination.
Thank you, Madam Chair. Good evening, sir.
Good evening. It's David.
Quick question. I think you would agree with me that you're not a land use expert, correct?
That is correct.
And you have no certification in aerial photography interpretation, correct?
I do not.
All right. And earlier...
Can I ask you, I want to know, can I get one?
That's beyond the scope of the cross, sir.
But are they available?
I do believe so.
Let's cut.
I'm sorry. Go ahead. I'm
Let's
sorry.
cut
I'm
this
sorry.
out,
I will.
okay?
Yep.
Let's stay professional.
Yes.
This
Yes,
is
ma'am.
this
Yes,
is
Madam
not
Chair.
a sparring match.
Thank you,
Yes,
Madam Chair.
You're correct.
So, Mr. Rickaby, you testified that there was quarrying operations between 1954 and 1957, correct?
There is a lease on land use record,
Okay.
on the land use record that shows that whatever I put in the document is what it says.
So it was leased to ATR for quarrying, correct?
I don't recall exactly what it says. I can flip it open, but what it says in the presentation is what it said.
Okay. And then similarly, you'd agreed that from some period through 1964, there was another lease that you found in the land evidence records leased for quarrying purposes, correct?
I don't remember what it says it was leased for, but it says what it says.
Okay. And then you testified, Mr. Rickaby, with respect to the farmland exemptions. Are you aware that my client never received farmland tax treatment? Farmland tax treatment.
That news would come as a surprise to me, given what I've seen in the public record.
Okay. Are you aware of what the tax assessment was before Mr. Chase bought the property?
In the appendices that I have provided, it is listed, but I do not have that memorized.
Okay, and off the top of your head, you don't know what it increased to after he bought it, correct?
I do not.
But if there was an increase, it suggests that there was no exemption, correct?
I am not an expert on tax valuations.
Understood. Mr. Rickaby, are you aware that the grassland easement that you testified to only encompasses 16.5 acres of the property?
I am aware that it does.
Okay, so it doesn't apply to the entire property?
I don't know that law. I'm not an expert on that.
Okay, thank you. And then finally, a couple of questions with respect to the noise testimony. What type of sound meter did you use?
I don't have it memorized. I think I have it open in my knapsack.
Okay, have you received any training about how to operate that?
Only the website videos that I have been watching since this started.
Okay, and Mr. Rickaby, do you know if that meter contains an octave band analyzer?
Yes, it does.
Okay, and do you know if the meter analyzer meets the standards prescribed by the American Standards Association?
I do believe it is ANSI certified, but I would have to double check.
Okay, what are those standards?
I do not have the number of the standards memorized.
Okay,
But I did research the standards, and when I bought my brand new noise meter, I made sure that it was the higher standard.
okay. Where were you when you were taking these measurements?
The initial measurements were taken from my office and my front deck.
Okay, so not the property line?
No, I did not go to the property line.
Okay. Did you take any ambient noise measurements?
Yes, I have taken ambient noise measurements.
Okay, what were those?
I don't want to testify incorrectly, but, you know,
Okay, so you're,
in the 50s.
okay.
What? I'm sorry.
In the 50s.
In the 50 decibel range.
All right, so the ambient noise is 50, and you're alleging in your report that the noise is approximately what when the quarry is running?
When the quarry is running, I have gotten readings between, that average in general between 55 and 65 decibels, depending on where and when, and I have videos of every noise recording I make, or almost every noise recording.
But the ambient noise is 50, correct?
Yes, and noise measurements are logarithmic, so every measurements are logarithmic. But yes.
Okay. And how high off the ground was the noise meter when you took these readings, sir?
I can't hear the question, I'm sorry.
Sorry, Madam Chair. How high off the ground was the noise meter when you took these readings?
The noise reader, again, I've taken the readings in several different locations. So the ones taken from the first floor would be, what's that, 4 feet? And the ones taken from the second floor would be the second floor of a house plus 4 feet,
Okay.
or thereabouts.
So 4 feet, and what would you approximate the second floor one to be?
I am not an expert on the height of a,
Okay. But so you would agree with me that you did not hold it 5 feet off the ground, correct?
I would not agree with that, no.
Okay. Are you aware of the noise ordinance standards set forth in Tiverton Ordinance Section 38-135A?
I don't know the section number. I have read the noise ordinance for the town.
Okay. Do you believe your readings meet the noise ordinance?
I am not a police officer, ergo, it would not be relevant for me to make a reading as to the noise ordinance. I am reading for the purpose of establishing a nuisance.
Okay. Thank you for your time.
Thank you.
No further questions, Madam Chair.
Thank you. Thank you, Mr. Rickaby.
Next witness is a member of the public. I have Mr. Wallace D'Souza, and I have for the board copies of a letter that he just handed me. I hadn't seen it before this evening. Certainly going to give a copy to appellant's counsel.
Is he going to testify?
He's going to testify as well. I don't want him to...
We have a rule on documents, but since he's a member of the public, I don't think that it would apply. Do you have enough copies for us? Okay. Thank you.
Just so the record. Yeah, just so the record, so the appendix that Mr. Rickaby testified to is not in this book, correct? The appendix?
Correct. Yes.
Are you going to supplement that at some point? We're going to want a copy because we're going to need it if this goes somewhere else, so.
Get copies of that. That was in the electronic submission.
Okay.
It's a Dropbox link because it's so voluminous.
Did opposing counsel get the Dropbox? Did you see the exhibits, the appendix? You got those?
Are we referring to the 288-page PowerPoint presentation or something else?
No, that's it.
Okay, then I have it,
You have
Mr.
it all,
Solicitor.
okay.
Thank you.
I just want to make sure that, so that also will become part of the record, even though we don't have it here. It was sent to the board electronically, and it
Yep.
is in the zoning planning board's office as an electronic file.
If you need hard copies, we can get them delivered to town.
I'm assuming that at some point we will eventually need it, yeah.
Gotta kill more.
Okay, thank you. I just want to make sure that we're
And has this been marked?
specifying what the record is.
Was this
7.
copy of the letter just marked?
Well, here's the problem. The appendix will be objective 7.
This
Well,
would
it's
be
part
8.
of the-
Okay, so
oh,
part,
Part of 6.
well, he said it was separate. So, I don't care how you, I just want to make sure the record's clear.
Let's make the appendix
And this one, 8.
a copy of this letter dated 3/1.
8.
Check yours.
Okay.
Yeah.
Say what you're going to say to the board.
My name is Wallace D'Souza. I live at 656 Highland Road in Tiverton.
Letter you brought with you.
Well, I'm familiar with the Jerome property since 1956. And in that time, there was never any quarry work going on. And I've never seen any trucks going by my house, because I live right on the street, until Tom Chase started quarrying.
Are you related to the
My father-in-law,
If it's easier for you to sit, sir, we could bring a microphone over to you.
No. All right. Paul Jerome was my father-in-law. I married his daughter, Carol, in 1956. So I went back and forth on that property for many, many years. And there was never any quarrying going on at the time.
Relation is Paul Jerome, Ed and Betty Jerome
He's a brother
of Ed.
of Ed Jerome, yeah.
What is this letter
Well, Ed,
talking about
okay.
that you brought today? You don't have to read the letter, you can just
No.
summarize it.
Ed bought the farm in 1972. The Jeromes moved to this property in 1923 to run the farm. And they bought the farm in October 1944, and Ed ran the farm. Ed bought the farm in 1972.
Who wrote this letter?
Paul Jerome,
Your
my
dad,
father-in-law.
father-in-law.
Yeah,
This is his handwriting on this?
yes. He wrote this 3/1/97.
And what was the reason he gave this to you?
There was a question about whether I could run a business on the property that I bought. And the zoning board agreed that I could run a farm. I was grandfathered in. So that's the reason he wrote this letter.
Is there anything else you want to say about the Highland Ridge Farm property?
There was never any noise of trucks or anything going by the house until Tom Chase bought the property. Ed Jerome ran a farm for years, had a dairy cattle. He gave that up, and in his later life, he cut trees down and split wood and sold firewood. He would split it and deliver it. And he would go by the house occasionally, delivering it mostly to Westport and Little Compton.
Nothing further.
Further board have any questions?
Just briefly, Madam Chair, no questions for this witness, but we'd respectfully object. I'm still not sure, even after the testimony, the relevancy of this particular document or its authenticity. Thank you, Madam Chair.
Okay, thank you.
Next, Joseph Bento. They'll swear you in and then state your name and address.
I do. Joseph Bento, the original 536 Highland Road.
What do you mean by that, the original 536?
Well, many years ago, it was split between the 536, the front and the rear, and I am in the front house, the original farmhouse to 536.
What do you want to tell the board?
I'm the third generation of my mother's family to live in that house. My mother is 96 years old and tells me, and as from what I've lived there for the last 20 years, there's never been a quarry there. Not in my lifetime, and she only remembers the 1959 instance where the gentleman from Fall River came in and took some rocks or gravel or whatever. When we were kids running through that area before Budway was there, before William Barton Reserve, before April Lane, there was no quarry there. There was a gravel bank where somebody would come in maybe every 10 or 15 years and take some gravel. It was a farm. The previous owners were farmers, period. There was nothing else going on there. Thank you.
When did you live? How long have you
2003, we bought the house from my Aunt Mary Jerome.
Mary, Jerome, Ed, and Betty.
My mother Ruth, Mary, Ed are all brother and sister.
Ed Jerome.
Is
Your
my
uncle?
uncle, correct.
Do you know when the quarrying ceased, Mr. Bento?
I do not. I do not. It was, we ran through there when we were kids back in the 70s and stuff, and it was just a gravel bank that we used to play in and get dirty in.
I have a question.
Yes, George.
I think you answered it, but I wasn't really focused much. How long you been living there?
2003, we bought the house.
Has it been peaceful? You could
It's been quiet.
take a nap,
There was
some birds.
My uncle would cut hay or corn or grow flowers or whatever, but there was no constant grinding of rocks and trucks back and forth.
You would have known if there was any, right?
Yes. I would
Thank
think
you.
that would be something I would recognize.
You're not an expert on that, but you would have known.
No, correct.
All right, thank you.
Just briefly, Madam Chair. So, sir, thank you for your testimony tonight. You've lived there since 2003, correct?
Correct.
So a lot of what you are testifying to with respect to the history of the property is based on what your mother told you, correct?
That, and we used to run through there when we were kids.
Got it. Respectfully object for the record that the majority of this witness's testimony is based on hearsay. Thank you.
Mr. Bento, let me just see if I can solve this problem. Are you familiar with the property before 2003?
Yes.
And could you go explain when your familiarity with the property started?
When we were little kids back in the 70s, the early 70s. I was born in 1962, and prior to my grandmother's death, we had family reunions there and whatnot, and all us kids would take off into the woods and come back for dinner, and that was how we spent our day. So we'd be in the waterfalls. Before a lot of the trails were finished in Fort Barton Woods, we'd be up in there. We ran from Evelyn's to Route 24 without seeing a house or a person, and that's the way it was back then. There was no...
And no quarries.
Right. Gravel banks, yeah, there was a gravel bank, and that was only intermittent.
Okay, and so you grew up there?
Pretty much, yep.
And then you've been there since 2003?
Yes. Previous to that, I was at 270 Highland Road.
So you've always lived in this
area,
neighborhood?
yes. Yep.
Okay, thank you.
So I also have a question. So if your mother ever told you about stories happening down at Evelyn's or anything, this is a hearsay thing, or you witnessed some of that stuff for yourself?
No, we go to Evelyn's.
All right, good.
Used to sell cohogs to Mrs. DuPont when she owned it.
She told you a lot of stuff. It's not a hearsay, stuff you witnessed as you grew up.
Yes.
Okay, thank you.
Mr. Romano, do you have any questions? Okay. Thank you
Thank
very
you.
much.
Thank you.
There are members of the public who want to speak. I don't have any other witnesses that I'm calling per se. I presume now we're at the time where the board throws it open to public comment.
Right. You know, anybody that wants to speak can speak, and I assume that most of you want to be heard about what effect, if any, this has had on the enjoyment of your property. I don't want anybody to feel that they haven't been heard, but I would encourage you not to repeat what other people have said. So, and to try to keep it down to 3 or 4 minutes, if that's reasonable. Obviously, if you have something to say about the history of the area that you're aware of, that's different. But any member of the public who would like to be heard can come up and be heard.
Can I ask a question? With 10 o'clock, I just want to remind the public to be careful at 10 o'clock. It's not 9:50.
Jonathan Clinker, 38 April Lane.
I'm sorry, could you repeat?
Jonathan Clinker, 38 April Lane. I do. So I've lived at 38 April Lane my whole life. I was born in 1998. My parents have been in the area since the mid-90s. They rented a condo on Highland Road while they were building the house. I'd also just like to point out for the record in regards to their affidavits, the first date we were going to continue, I believe it was Friday, June 15th, which the board had suggested we meet. They would have been able to make that meeting, and then Attorney Parks was unable to come and is also no longer here tonight, so that is why they're not able to be here in person. I've been on the 356 Highland Road property several times in my life, both through hiking through Highland Woods, getting lost, or Fort Barton, getting lost. I've been on the property several times back when there was cows and the such, probably in the mid-2000s, like between 2010 2016. There was never any quarrying operations, and also the rock crushing and all of that Mr. Chase has been conducting, I can hear inside of my house. I've been on I'm a law student, so I've been trying to, read text.
My sympathies.
Just finished my first year law school, and having rock crushing going on in class, and while I'm trying to read case law is not particularly helpful. So I've never heard any of the noises that I am currently hearing over the last 9 months or so, since Mrs. Jerome's death, at any point in my time in my house. And again, I can hear that in my house with the windows closed, fans on, AC on, TV on, you can hear it. And I've never at any point, I don't know how legally far back I can go is in my childhood, but I've never heard any of that. And then another thing just from the CDC website I would like to point out, silica dust, which is created by crushing and or cutting of materials, such as stone, rock, concrete, brick, or block, is a Group 1 carcinogen. And prolonged exposure to that silica dust, which again is created from crushing of rocks, can lead to lung disease and other lung ailments, including lung cancer. And again, that is from the CDC's website. We have video evidence from drone shots and various other things of the rock crusher in operation, and you can see the clouds of dust going into the air. We believe, have not tested the soil, but presumably that is in the runoff that goes into the gut, and also that dust goes into the air. You know, might be having some with your clam chowder down in Evelyn's, with the proximity of how that goes. And then also, I just like to call the board's attention to the fact that eventually, given Rhode Island's history with quarrying operations, these things tend to go bankrupt or are abandoned, and the towns themselves are left to clean up the mess. There's various, and I have various news articles from these types of places, but just one off of Brayton Avenue in Tiverton. That's been abandoned. I'm not exactly sure for how long, but I know the town's had issues with a gun range being operated in there and a sort of motocross park. I'm not sure if that was attempted to be a legitimate business or not, but all that sort of activity taking place in that abandoned quarry. I know the other quarry off of sort of near Linden Lane has caused multiple water lane breaks since 1999. Especially, at least 2 were in 2014, as I have an article here from the Herald News discussing that. And with the fact that this quarry is near the wetlands and the gut in Nanaquacket Bay, those types of public works interruptions and pollutants can very seriously harm the nature that we have here in Tiverton that we all know and love. And just lastly, again, in regards to that silica dust, it's not like it just reaches the folks that abut the quarry or are a street over from the quarry. It goes into Fort Barton, it goes into the town hall, it goes into Fort Barton School, all the people eating outside of Evelyn's. And so ultimately, this quarry is a serious public health situation and also an attractive nuisance, again, at the point where this is abandoned. As to my knowledge, there isn't appropriate fencing around the entire property, so children and tourists could get lost from Fort Barton.
I don't mean to cut you off, but I think we're getting a little far afield.
Yeah, and so that is all I have.
Thank you very much.
You're welcome.
Anyone else? Come on up.
Hello. I do. My name is Rebecca Lee. We directly abut Highland Farm. My husband and I live at 150 Old Bulger Marsh Road. We bought our house in 2013, and at the time we bought our house, there was not an active quarry. Our house, on both sides, you can see the abutting property. It was, and still is, zoned residential and was a farm. We recall the previous owner, Ed Jerome, used to hay the field each year, and he actually would notify us when he was coming by on his tractor to do so. He never cut down trees. He did not remove earth that we were aware of, and we've been there since 2013. We have never had a negative interaction with Ed Jerome. There was never any noise, earth removal, or crushing or clearing of trees until 2019. The new owner, as we know, Tom Chase, acquired the land in 2016, and that's when our personal nightmare began. And the reason I'm sharing this with you is because we have a history with this owner and also various developments that were proposed, which would have negatively affected our property. And what we know is that the intent was to develop the property, and when that was denied without prejudice in 2018, in August 7th of 2018, he then decided to become a quarry operator. And so after 2 years of those subdivision applications, he was gonna pin a road to our property. I think there's gonna be an 18-foot drop, if I am correct. So that's how close we are. It was gonna affect our well. So now what we're dealing with is constant noise. I can see the bulldozer from my yard. It's right next to my child's playhouse. There's dust, there's noise, there's rumbling. My husband, who has to work at night, sometimes sleeps during the day. So you can imagine what that's like for us with the noise lately. I work from home and I have a 4-year-old. So when this bulldozer is going by, I don't want her outside. I want to enjoy my property. I don't want to deal with this anymore. It's been years and years and years, and we are standing here as a community saying it is not fair, it is unhealthy, our property values, our wells, our health and safety are at risk, and this has been allowed to continue, and it has to stop.
Thank you.
Thank you.
Anybody else? Okay, seeing none. Oh, I'm sorry, go ahead, come on up. You were a little hesitant there.
Getting old.
Aren't we all?
Yeah. Yep, I do. My name is William Ewing. Ewing, E-W-I-N-G. I live at 475 Highland Road, directly across your own property. I bought that property in 1978 from Highland, the developer of Sandy Point Farms. He couldn't get a permit to put condos in there. So I designed a house that would fit on the property, and I contracted it myself. I've been there since 1979. It's been a very peaceful place to live. Of course, I had a big lot. I have fairly serious tinnitus, ringing in my ears from shooting my brains out since I was 7 years old. But nothing has bothered me. The motorcycle's going down to the point on Sunday. We look forward to them going down, coming back. But this rock crushing operation is really a problem because it acts up my tinnitus, and I can't sleep at night. And after they've shut them down, I still hear them for another 4 or 5 hours. And I didn't sign up for this, but I just thought I'd put my comments in. It's affecting a lot of people. That's it. Thank you.
Any cross-examination? Okay, thank you very much. Anybody else?
Hi. Yes. I'm lot 130. I'm John Mello. So I am the hammer and the handle. Where he's developing right now, or doing the rock quarrying, is in my front yard.
Is the hammer part of the land?
So when you look at the map, you'll see the hammerhead and the driveway's the handle. He just recently started doing this stuff within a couple of years. We've been there since 2006. And we've had nothing but quietness since then.
You want to tell us what's going on in your front yard?
Anytime there's anything going on, if I was to go to the town, he just disappears, and we stop fighting the fight because he's actually in a lawsuit with us. He's been trying to sue us. And we gave up the whole lawsuit and stuff, and we asked for a 100-foot setback, and he cut all the markers all the way up to the property lines, all the way around our property. So we have been dealing with a lot more since 2007, 2008.
I have a question. Your property is the one had the easement and the argument, right?
Yes.
What's it, your property?
He was trying to use our driveway as access to the property.
And that's been going on for a while.
Yes.
Is that still going on?
Yes.
Okay. And you said you've been there since 2006?
Yes.
And when did you start having problems?
Roughly about 3 years ago.
And what are the problems that you've had?
He's doing the rock quarrying. Sometimes it's on Saturdays, sometimes it's on Sundays. During the week, I don't know what's going on because I'm at work from 6 o'clock to 3:30.
Mm-hmm. And anything else?
No.
Okay. Thank you.
Thank you.
I do. Hi, thank you. I'm Norm Whitehead, 583 Highland Road. And my wife and I moved in 2016 after a 3-year search for a home anywhere from Westerly to halfway down the Cape. We settled on Tiverton. I retired from Raytheon. We had a lot of people I knew lived in Tiverton, never heard of any problems in Tiverton. One place we did not look specifically because of past zoning problems was Rehoboth. It could have been all solved now, as far as I know, but their reputation precedes them. So it could have been problems 30, 40 years ago, people getting pig farms next to their nice new home. And so you are not, right now, Rehoboth. So the only thing I can say, I'll skip sort of to the bottom, had the quarry been operating when my wife and I were looking for our retirement home, I would not have bought my house at any price. I wondered if any of you would buy this house that's adjacent to the quarry, unless it was an investment property. You wouldn't want to live there with this going on.
And why is that?
The noise. You've all probably heard a helicopter going over and the buffeting where it's going like that is Dave Rickerby sort of pounded on here, but you felt that sound goes through your walls to your house. It's a low frequency sound. It just pushes on the whole wall so the whole inside of the house vibrates. It's not good for foundations or, I assume, wells in the area, but the noise for me and dust is phenomenal. They've been violated by the DEM on mid-February for stormwater runoff. And as of the rainstorm the other night, I walked to the bottom of the gut, to the bottom of the drive coming out of the quarry, and there are large puddles that have now evaporated that have a ton of white dust in them. So when cars go by, it stirs it up and it goes all over anybody who's walking in the area or the kids who feed the ducks right there. A car goes by and you see the dust devils like that of the, it has to be stone dust that's washed down the hill. They've done nothing to remediate it. We've checked with the DEM records that are online, and they've, as far as we can tell, nothing has changed with remediation of the stormwater runoff. So that's running down into the gut, into the Sin and Flesh Brook, subsequently into the gut, and there was large pools of junk coming down the Sin and Flesh Brook this afternoon. I don't know if it could be organic or superfine dust from the crushing operation, but it's beginning to go underneath the bridge and fill that end of the gut. So it's an environmental disaster, and it is a danger. And for just one brief thing, that any of these quarry operators seem to get an LLC, take their profits, leave a bankrupt LLC behind for the town to go talk to, and get out of town. I've seen the Kid Quarry that's at the south end of Fish Road. It looked fine, sort of okay from the road. You can see that it looks like there's a fence up there. I went to the circle that's up above there with a house. There's an empty lot, so I walked back and stepped over the fence about like like that. It's in disrepair. Who is responsible for that? Is the town responsible for that now? Is it a bankrupt LLC they go after? This isn't a,
Well, it's a little speculative and kind of beyond our scope for tonight.
I know, I just believe that's the kind of thing that will happen. And we just see a lot of operations going on without permits. A bridge being built across the Sit-in-Flesh Brook up by the pond. I guess I can only say Mr. Chase's attitude seems to be, permits, we don't need no stinking permits. And
What was the quality of your life when you first bought your house?
we could sit on our terrace and look at the gut, look at Nanaquacket Pond.
Well, when did you start hearing this disruptive noise?
It was August 27th or 8th, 6 days after Mrs. Jerome passed away.
And you hadn't heard you hadn't heard truck activity before that?
Not coming from there. Once in a while, Mr. Clement Rose would drive by in his truck for his business, but not going up to the quarry.
And you didn't hear any noise from rock bashing?
No, nothing like that.
Did you see any commercial activity
No,
emanating from that property before Mrs. Jerome died?
no.
Thank you.
Okay, thank you.
I don't want to shut anybody off, but we usually stop at 10, and I have a feeling we're going to go over tonight just because we still have arguments from the lawyers, and then we have the board's deliberations. So is everybody who wanted to speak, have they already spoken? Okay. Thank you. Well, at this point, we're going to close the public hearing and take legal arguments. Yes.
Thank you, Madam Chair. I wanted to go over some of the legal points and expound on some of the evidence that we heard today. First, as by way of update, Madam Chair, today my office filed a declaratory judgment action in Newport Superior Court. The court has not filed or essentially given us a CA number yet, but we will tomorrow, and I will immediately forward it to Mr. Marcello and Mr. Romano. As you know, my colleague, Mr. Parks, essentially argued last time that this board respectfully doesn't have subject matter jurisdiction pursuant to the Carty case. I won't belabor that point.
Okay.
But suffice to say, the Superior Court now has jurisdiction over these 5 cease and desist letters, and pursuant to the Carty case, that's the appropriate place for this dispute. So I wanted to make everyone aware of that. I'd also like to encourage the board, consistent with the way this exact board ruled in, I believe it was 2020 or 2021, with a prior cease and desist with respect to this very property. It ruled that the building official and the zoning board doesn't have subject matter jurisdiction to hear an appeal and dismiss the appeal. And that's in the record as well.
I thought we determined that we didn't have subject matter. We had no jurisdiction to determine whether something was a pre-existing non-conforming use.
That's right. That's exactly right. Thank you, Madam Chair.
And I think that we're assuming that now.
Yeah, and I'm going to get into that in particular later. By way of updates, that was my first update, Madam Chair. My second update to you is I wanted to make this board aware, and you, Madam Chair, aware of a very concerning event that happened last Friday. So I believe Mr. Hoyle, in his capacity as the building official, descended upon the property accompanied with 2 Tiverton police officers and proceeded to order those working at the property to immediately stop all operations on the site. And that is deeply concerning given what the statute says about stays and what the Tiverton Ordinance says with respect to stays. So specifically, Mr. Hoyle ordered them to cease all operation and ordered that nothing extracted from the property shall be removed. So I called Mr. Marcello and this was that Friday, and I essentially said, Mr. Solicitor, we don't think that this is appropriate given the statute. Mike said he would get back to me. I followed up with an email essentially outlining our concerns, that specifically Rhode Island General Laws 452465 and the Tiverton Zoning Ordinance essentially says that while this matter is under appeal before this board, there's a stay that goes in place unless the building official has certified a, quote, imminent peril to life or property. Madam Chair, we heard today from Mr. Building official, he said he didn't. He never did that. So as a result, there was a stay in place pending the decision of this board, and instead he went in with 2 police officers using the police power of the town and shut down operations from the town. So I wanted to make you aware of that. I have an email that I want to introduce into the record. It's essentially an email from Mr. Romano, essentially agreeing with our position that there was a stay in place. And I wanted that entered for the record, essentially to say that Mr. Romano agreed that there's a stay in place, and as a result, I would say the shutdown was illegal.
I'm going to object. I object to the characterization. I cite the statute. My response email speaks for itself, but this is totally out of bounds.
This is interesting, but it's not really germane to the matter that's before the board tonight.
Yeah. Well, Madam Chair, the law has been violated. And
we're not the police, okay?
Really?
This is the first time that I'm hearing about this, and, it's concerning to me, and
Thank you.
I knew nothing about it, but it's not before us tonight.
Okay. May I introduce that into the record?
I don't see how it's relevant to anything, other than it's certainly relevant to whatever you're going to do in Superior Court.
Okay. So my request to add this to the record is denied?
Yeah, it
Okay.
is denied, because I don't think it's relevant.
Okay, thank you, Madam Chair. So, moving on. My client received a visit from the Mine Safety and Health Administration this week, and essentially, there was a complaint from somebody that the federal government came to investigate. And I would like...
What does this have to do with what is before us tonight?
Because there have been allegations, Madam Chair, that my client is operating an unsafe mine that essentially is having a detrimental effect on the neighborhood and operating illegally. I have the report from that federal agency. Essentially, there's 0 citations that were issued against Highland Ridge. However, there were 3 minor violations that were issued against the operator there. One for failing to have mirrors on a bulldozer, and...
I don't mean to cut you short, but we're here on the 5 cease and desist orders, and whether the town has the authority to require licenses and special use permits, and what happened subsequently is really not before us.
Yeah.
It's whether the zoning official erred in issuing these violations.
Understood. So with that, I assume that my request to add this to the record is being denied?
Yes.
Okay, thank you, Madam Chair.
I just don't see how it's relevant to, that's nothing that was in front of him when he issued the cease and desist.
Understood. But in addition to that, we've heard from a lot of different folks, and a lot of different evidence has come in that wasn't in front of, the building official at the time.
Well, I think it was in front of the building official. The building official said that, or the zoning official said he was getting a lot of complaints from the neighborhood about the noise, the traffic, et cetera, et cetera. So that was very much part of his decision.
Okay, thank
basis
you.
for his decision.
Thank you. I'd like to get into the discussion with respect to the way the cease and desists are worded. Specifically, we believe that this 5 cease and desists are fundamentally flawed because of a position that the town has already taken in existing Superior Court litigation. So there's a case, and the civil action number, Madam Chair, is NC-2021-0042. Now, in that case, the town has taken the position that the uses on site are illegal and not pre-existing and not non-conform and not pre-existing non-conforming uses. So they essentially have said that there's no right, no pre-existing grandfathered right to operate anything.
I'm sorry, I didn't mean to interrupt. That's the Newport case that your client filed against the town.
That's correct.
So that it's your burden to show a non-conforming pre-existing use. That's your burden, right? Town answered that complaint. That is being litigated now. There's been no decision of that case whatsoever.
Correct.
I believe, and correct me if I'm wrong, but if I look at these cease and desist orders that were issued, they take the position, the building inspector takes the position, regardless of what that is, assuming that you have a non-conforming pre-existing use, you're still violating ordinance of the town, including not getting a special use permit because you're expanding beyond the original amount, not having a proper earth removal license. Those are the kind of issues. So I understand that you have filed a suit against the town alleging that you have the right to quarry on this property, and I respect that. But and as you know, that is your burden to prove that your client has that right. But that's in a different forum, and we're in a forum where we are now asked to stand in the shoes of the building official who issued 5 cease and desist orders. And it's now based upon the evidence that's presented in this hearing, whether or not those cease and desist orders are factually correct. Did he meet his burden? They're standing in the shoes of the building official as if they're the building official now. So I'm not sure how that's relevant about the case. To say it's inconsistent, there's one issue that you're suing the town, and the town has responded and answered. And we have, on another track, we have the building official issuing cease and desist orders based upon what he believes are violations of the zoning ordinance. And I know you're arguing, and I respect the fact that you're arguing that you believe that pre-existing non-conforming use supplants every zoning code, every provision of the zoning code you can possibly have. And that's your position. But that's for now the board to decide whether or not, in spite of that suit pending, and it's clear in the opening paragraphs of each of these cease and desist orders that irregardless of assuming arguendo, right, assuming that you're right, you still have to comply with the zoning ordinances that are in place, including getting the licenses, including getting a special use permit. So that's kind of what's before us. We can't decide, and as this board correctly held when Mr. Chase was before us many months ago when he was cutting trees, we can't decide whether he has a pre-existing non-conforming use. That's your burden to prove. That's why you have a case in Superior Court. These issues are related to the interpretation of the zoning code by the zoning officer, even assuming that he has a pre-existing non-conforming use.
I understand. If I may, my points are, well, number one, we do not believe it's appropriate to take 2 different opposite positions, one in Superior Court and then one through this track. So you're right, you're doing 2 different tracks. I am respectfully bringing up the fact that they're exactly opposite positions that the town has taken. Furthermore,
well, just so I'm clear, we're taking an opposite position because, one, you filed suit against us, right? And we have an obligation to defend the interests of the town. And number 2, we now have a building official. So it's okay to plead any alternative, right? You can plead, 2 different things. So I'm not sure. I know you believe that's inconsistent, but again, we're faced with, one, we're answering a suit filed by you, your client, and now you're faced with upholding or overturning decisions of the building official on other grounds.
Yeah.
But
and just one more point on this, and I'll move on. We believe that the way the cease and desists were worded, assuming arguendo that you have a pre-existing non-conforming use, but we're not waiving that argument, right, with respect to Superior Court, that is an attempt to sidestep Carty and essentially say, listen, we're not going to talk about pre-existing non-conforming uses. We're just going to talk about everything else. It's an end run around Carty, and that's what we're respectfully bringing to the board's attention.
And I appreciate that, and that's a position that you're taking. But at the end of the day, it's your client's position that because you believe you have a non-conforming pre-existing use, that you are allowed to do anything you want on that property. Your client's allowed to do anything you want on the property, regardless of our zoning code, regardless of a special use, need for a special use permit, regardless of the fact that our ordinances require an earth removal license. So I get it, and I get it. And we're not going to solve that here tonight, but I just want my board to know that that it's not inconsistent and that we're dealing with different issues. Because if you look at the Newport case, the Breakers case, it's clear that what's happening here is that we are looking at an interpretation of the zoning code made by the zoning officer, and that is consistent with, I believe, the Breakers case. So we're not making a decision, I agree, whether it's non-conforming. And it may be inconsistent positions, but we're now with 5 cease and desists before us, and that's what this board has to decide, whether or not those cease and desists were validly issued, and there were factual bases that will sustain appeal by the Superior Court.
Understood. And then I'd like to point out, and this is discussed in the papers that were filed with the board, there's legislation that's Tiverton specific from 1973 that exempts granite and limestone from any oversight from the town. So that's another piece of this puzzle that needs to be considered by this board as well, in addition to we believe this board doesn't have jurisdiction. Even if it did, we have that law to contend with, where it specifically excludes and exempts granite mining and limestone mining. So we have that. In addition, there's been a lot of...
I got to say something.
Sure.
I am not a lawyer, and boy, I worked hard all day today. Please focus. I appreciate what you're trying to do. We've already addressed this with a different attorney. We're going to hear it, and we're going to make a decision tonight. You've said that, and your partner said that before, and I'm getting insulted by it. I'm not a lawyer. I'm not going to sugarcoat it. We're going to hear it, and we're going to make a decision. And I want to go home tonight. So let's focus on what's in front of us. 5 cease and desists. Focus on them. Thank you. I want to go home tonight.
Thank you.
Thank you.
Moving on, there's been a lot of discussion about alleged abandonment of pre-existing non-conforming uses. As set forth in the Carty case, quote, a mere discontinuance of a non-conforming use for a period does not constitute abandonment of the use. So we've heard a lot of allegations. One of the allegations was that my client received special treatment tax-wise for farmland. And I want to make it very clear that my client never received that special tax treatment. So that's one of the issues that are being cited by the opposition, why my client has allegedly abandoned their rights, and that's categorically false. I just wanted to make that clear for the record. And then finally, and this is my final point, and I really say this with all deference and respect to Mr. Romano and Mr. Marcello. They're both highly, highly regarded members of the bar, and they're highly competent, and the town is lucky to have them as solicitors. But I need to make this point because there's evidence that came out while we were having the cross-examination with Mr. Hoyle that gives me and my client pause. So specifically, Mr. Morano, Todd Romano is a partner at Lewis Brisbois in Providence, Rhode Island. He is here representing, Madam Chair, the building official. That's his goal. That's what he's doing here today. Now, Mr. Marcello is counsel to this board, and he is also a partner in the Providence office of Lewis Brisbois. So we have 5 cease and desist letters that have been essentially issued by the building official in conjunction with Mr. Morano of Lewis Brisbois, and we're appealing to this board, who's represented by Lewis Brisbois, the exact same firm. So we respectfully, and with all deference and respect to Mr. Marcello, and Mr. Romano, we respectfully object to the fact that the building official and the zoning board is represented by the same firm and lawyers in the same office. Moreover, it appears based on Mr. Hoyle's testimony that Mr. Marcello was in on the meetings with Mr. Romano before these cease and desists were. So there were discussions about these cease and desists that Mr. Marcello participated in.
We precluded that testimony on attorney-client privilege grounds.
Exactly, Madam Chair. So that's my point. Mr. Romano jumped up and said attorney-client privilege. And I get that, but you can't have attorney-client privilege between the building official and this zoning board. The zoning board sits over the building official and rules as an independent body pursuant to Rhode Island law about these cease and desists. The fact that Mr. Marcello is representing the zoning board and participated.
It's an insult to me, what you're just saying. First of all, I had no idea where he worked. Neither does the gentleman down there. It's an insult to me to think that I'm sitting here and neither you, him, or this gentleman here going to decide what my decision is because they work together. So it's an insult for you to step here and tell me, as a board, I'm sorry, excuse me, as a board, it's an insult to me that you tell me that I cannot make my own mind and somehow we talked into what we're going to say. It's exactly what you're saying. We're going to be decided because the attorney deciding.
I want to say something, and that is, Mr. Marcello does not have a vote on this board. And we don't do everything he recommends that we do. We have made decisions contrary to his advice. So I see the point that you're making, and
So respectfully, I just wanted to place that on the record and object for that.
And I respect that you put on the record. I just wanted to clarify. I believe there's a Superior Court case, or maybe a Supreme Court case, that indicates that, for instance, if this board is hearing an appeal from a planning board, which they usually do, that if I was a lawyer for the planning board and then gave them advice, and then also could serve as the lawyer for the zoning board that hears that appeal, I believe it's the case that said there is no conflict on that, and I don't believe there's a conflict. I will say, and it's noted for the record, if you believe there was a conflict, your remedy was to note that conflict at the beginning of the hearing, not at the end.
Well, with respect, I understand exactly what you're saying. The testimony came out during this hearing, so I didn't have an opportunity to say it at the beginning of the hearing. So this was my only opportunity. So with that, I'm happy to answer any questions the board might have. If not, I will reserve and rest.
Yeah, right.
Okay, thank you.
Thank you.
Todd, do you want to be heard?
I appreciate it, only because we need to make the record here, and I will be quick, and I apologize. So even assuming Highland Ridge has a pre-existing non-conforming use, it does not have a carte blanche right to conduct earth removal, quarrying, and mining activities. The town, in accord with the general laws and the case law, has adopted reasonable regulations as to each of those activities in an effort to thwart a nuisance from arising and to protect the health and safety of its residents and to preserve the environment. Highland Ridge has, however, elected to ignore those regulations. Based on the evidence presented, just in the cease and desist orders, I think you can affirm them. But then you have all this other evidence that's come in since, which only bolsters and solidifies the position that the zoning official took in those cease and desist orders. And to be clear, you are allowed to consider all of that evidence because you do today sit in the shoes of that zoning official. There's no doubt about it. And I would reference you to Zylestra versus Barrington Zoning Board of Review, 417 A. 2nd, 303, Rhode Island, 1980, as well as Murphy versus Zoning Board of Review of South Kingstown, 959 A2D, 535, Rhode Island, 2008. Moreover, it only makes sense that you can accept the new evidence. If that were not the case, then the party appealing, Highland Ridge, would be deprived of its rights. Makes sense. Furthermore, you can consider, obviously, the evidence from the abutters you have heard, because this is a public hearing pursuant to Rhode Island General Laws 452466, and because many, if not all, are aggrieved parties pursuant to the definition in the zoning statutes, which includes those whose property will be injured by a decision of any officer or agency responsible for administering the zoning ordinance of a city or town. There was some discussion regarding the affidavits. Your rules specifically provide, the weight to be given written submissions by persons not present and available for cross-examination shall be determined by the board in its discretion. This board is wise enough, skilled enough to make those decisions. I'm not going to reiterate all of the evidence that you should consider in this matter, but I just want to point out one thing: how crystal clear it became when Mr. Rickerby put up all those aerial photographs, and when he pointed out with the yellow star the Area 5, which was the previous historical quarry and gravel pit. and how when you look at Town's Exhibits 2 and 3, how the ecosystems reports, how that starred area matches up exactly with what Mr. Chase's own expert was identifying as the historic and now defunct gravel pit. I'll leave it at that.
Randall Souza for the objectors. I'll be very quick because what the witnesses said is a lot more important than what I'm going to say. But I have to go back to the appellant's argument makes no sense to me whatsoever. This is an R40 zone. It's not a house, okay? It's a gravel bank or a granite quarry or whatever the heck it is. So it's either one of two things. It's either an illegal use or it's a legal non-conforming use. Whether it's an illegal use is a subject of a separate matter in Superior Court, and the town is entitled to plead in the alternative. So what the building official did here is he said, I'm going to give you the benefit of the doubt, and I'm going to assume it's a legal non-conforming use. You're still violating the zoning ordinance 5 ways. Now their response is, you can't regulate me at all. That's a crazy argument. If I have a legal non-conforming house on an undersized lot and it burns down, I can rebuild on that footprint. I have to get a building permit. I have to have electrical inspections. I can't thumb my nose at the town and say, this house has been in my family for 100 years. I'm building it on the exact same footprint. Leave me alone. I'm going to do whatever the hell I want over there. I mean, that's crazy. Do they think they could do blasting at 2 a.m. tonight because hours of operation doesn't matter to them? You can't regulate them? I just don't understand that. And I would just point out the third prong of the Carty case says that the expansion is not inimical or harmful to the public. Well, you heard from people who are living a daily nightmare next to this thing. And the record is replete with whatever there was there in the 50s, 60s, and 70s being abandoned for a long time. Your zoning ordinance says 1 year constitutes abandonment, which of course they say doesn't apply to them. But it's 1 year. This was abandoned for decades. You know, kids were running through those fields and gravel pits. There was nothing going on there. And what happened here is out of pure spite and an effort to monetize this money, the owner said, be careful what you wish for, neighbors. You don't want my 5-lot subdivision? Get a load of what you're going to get now. And they've been miserable for the last 10 months, and it happened a week after Betty Jerome died. I can't stress what a clear case this is of abandonment, unlawful expansion, thumbing your nose at the ordinance, and they can argue in Superior Court that it doesn't apply to them. But the Breakers case is clear. You can make factual determinations. You can decide whether the building official erred in issuing these 5 cease and desists, and I would strongly urge you that he did not err. They should be affirmed. Thank you.
Okay. We're now going to close the hearing, and we're going to go to begin our deliberations. I don't know who wants to start? Go ahead.
Our job is to determine whether or not the building official erred in issuing 5 cease and desist orders. And the assumption we started with was that this is a pre-existing non-conforming use. And given that assumption, you look at the 5 cease and desist orders, they're all consistent with that requirement. They apply if, in fact, this is a pre-existing non-conforming use. So I think that there would probably be a good argument for abandonment, but that's not before us. So I guess we can't go there, but I think it's pretty straightforward. Maybe others disagree.
Even if we take it on the non-conforming issue, the fact that they expanded way beyond the percentage, they're in violation just by doing it, even if they assume in their head their right, and they have the right to operate this place on based on non-conforming pre-existing, no pre-existing non-conforming. In fact, the cease and desist actually address that and tell them, even if you believe it, not see as though you are, even if you believe it, you are going way beyond what you're allowed to. You're going beyond the scope, you're going beyond the percentage. And you know what? Legally, we're here to address it legally. This is unfair to a lot of people who have to put up with this. And I know we're not probably supposed to address all the feelings, but this is nuts. They are absolutely should stand the cease and desist. They want to go to court, they want to play lawyers, and fine with me, but not here.
I just want to affirm that I believe the building inspector has made the right decision to issue the cease and desist. And, you know, we have to have some kind of control in town, and he's the guy that's doing it, so.
Well, I'd like to make, I'm in agreement as well, and I'd like to make a motion to affirm the building inspector on all 5 cease and desist orders.
I second the motion.
Well, I've got to state my reasons for the record.
Okay, go ahead, sorry. I just want to go home.
If you want to leave, you can go.
I just want to go home.
The matters before the board are 5 cease and desist orders that were issued by the zoning official on March 22nd, 2023. The first for expansion of quarrying and/or mining beyond 25% of the area that existed as of June 4th, 2001, in violation of Article 14, 3B, without obtaining a special use permit from the zoning board. 2, the failure of Highland Farms to have a survey prepared by registered land surveyor showing the excavated areas of 536 Highland Road as of June 4th, 2001, in violation of Article 14, Section 6. 3, for earth removal without a license as required by Chapter 38, Article 3, Division 2, which requires an annual license, and no plan was prepared by a registered engineer as required by the statute, or ordinance, I should say, that earth removal and quarrying impermissibly expanded into areas that had not previously been identified or intended by any objective evidence for future quarrying activities, and which have had a substantially different and adverse impact on the neighborhood than that which existed in 2001. And lastly, for the retail and wholesale sales and storage in violation of Article 4, Section 10, Sections E and F in an R40 zone, Section 14A. There's no question that the zoning official based his cease and desist orders on aerial photographs of the area, complaints and input from the neighbors, and our applicable zoning ordinances. Counsel for Highland Farms counters that this property has a long history of mining, which is continuous, that Mr. Jerome, I was in the record that Mr. Jerome obtained a permit in 1974 for 610 Highland Road, which is not even the address of the property in question. Highland Farms asserts that this board is without jurisdiction to regulate granite quarrying, and that the zoning board is not the appropriate enforcement agency, and suggests that the only relief available to the town is an action for injunction before the Superior Court pursuant to Zoning Ordinance Article 18, Section 5C, which is no doubt where this case will end up. Highland Farms takes the position that they can continue to quarry, move earth, and mine without any restriction imposed by the town because these activities were a pre-existing, non-conforming use. There's no question that the property at issue is in an R40 zone and that it is operated as a farm with some quarry activity, though the amount of this activity is a matter of substantial dispute. Highland claims it's continuous. The son of prior owners, through the affidavit of Mr. Jerome, and other landowners who have lived next to this or near these premises for many years, have submitted affidavits and testified that no quarrying or extraction activity was engaged in for years until Mr. Chase purchased the property with a few exceptions for the blasting of a basement, and that quarrying activities were essentially abandoned as defined by Article 14, Section 3. We know that a license was obtained by Mr. Jerome in 1974 for 601 Highland, but there were no subsequent licenses applied for. We know that there was a previous cease and desist order that was issued for gravel activity in 1989 when no appeal was taken by Mr. Jerome. There has been no earth license has been sought or issued since 1974, that no survey was ever prepared by a registered land surveyor showing the area of excavation of 536 Highland Road as of June 4th, 2001, as required by Article 14, Section 6, that no bond was ever posted in accordance with our ordinances, that no special use permit was ever sought or granted as required for any expansion of quarrying, and that beginning in September of 2022, almost immediately after Mrs. Jerome passed away, the neighbors have been subjected to rock crushing, strip mining, constant traffic overburdening rural roads, reverberating walls, and banging, which made working from their homes impossible. There's been also concern about well water, the effect of this on well water, on dust, and potentially carcinogenic rock dust that could pose a hazard to the community. The town has taken the position, as it must at this hearing, that the quarry is a pre-existing non-conforming use. But Highland is still subject to town ordinances that regulate quarrying, earth removal, expansion of quarrying, and the like. Our Supreme Court has upheld ordinances that regulate pre-existing non-conforming uses. In Kingsley versus Miller and in the Carty case that's been cited by almost everybody to this litigation. I also cite the case of South County Sand and Gravel, which was Judge Thompson's decision sitting in the Superior Court. And I think that case can be harmonized with Carty. I think it's beyond question that the zoning officer has the authority to enforce our zoning ordinances under Article 14, Section 5 and 6. I reject that the town's only remedy is to seek an injunction in the Superior Court. Clearly, the town has a vested interest in enforcing its own zoning ordinances, and that's our obligation as a zoning board to see if there was justification for issuing these cease and desist orders. The issue here is whether Highland Farms and its predecessors in interest have conformed with the provisions of our zoning ordinances, which the town had the authority to promulgate. And Highland stands in no better shoes than its predecessors in interest. Mr. Jerome got a license for earth removal in 1974, which is an acknowledgement that the statute and the ordinance pertain to him. He never renewed the license, nor did he provide the registered land surveyor survey or post a bond, and he never applied for a special use permit. Now, the butters have raised a substantial question of abandonment, and substantial evidence has been introduced in support of that proposition. From the affidavits that we've received, as well as the presentation of Mr. Rickerby, which I commend him on his thoroughness. These neighbors have lived near the subject property for varying degrees of time, and they attest to the fact that this was a bucolic, peaceful, relaxing neighborhood, and that they never heard any evidence of quarrying, mining, truck activity, or any type of commercial activity on that property prior to Mrs. Jerome's death. Mr. Stewart walked the property, rode his bike, and he's been living in his home since 1987. Never heard or witnessed any noise or activity associated with mining, quarrying, blasting, or earth removal. Mr. Bento testified that as a child he played in this area and there was nothing going on. We can see from the photographs that the aerial photographs look like this parcel was a golf course. I mean, it's all green. There's no digging, no rocks lying around, no nothing. And the affidavit of Stephen Jerome is particularly relevant. He's the son of the prior owners. He lived on these premises or as an abutter for 54 years. He talks about working on the farm and his day with his father and the logging activities they engaged in. He remembers his parents provided gravel for some development of the Old Harbor Mall in 1971. And when his parents became the owners, they sold stone that was loose stone on their property for other people to build stone walls or breakwaters. And he believes that his parents abandoned the intent to quarry. He states that in the mid-'80s, his parents abandoned any earth removal activities when they concentrated on real estate development, and he recounts the subdivisions that were created. His assertion is corroborated by the fact that on November 29th, the Jeromes were served with a cease and desist order for operating an earth removal operation on the land because no bond was posted, nor were any permits issued to them for that activity. No appeal was taken. And that is when we see Mr. Jerome and his wife selling off their land for single-family homes. When his parents were unable to develop the land because of lack of access, they entered into, there's some testimony that there was contemplation of this property being sold to the land trust. And the Jeromes hired Mr. Chase as their realtor, and he bought the property instead of the land trust. Mr. Jerome indicated his parents had never operated gravel crushing machinery, operated a pile driver, or used any heavy equipment to uncover or mine any ledge at the site, and that the granite was loose granite. To his best of his knowledge, in 2001, there was no earth or granite removal of any kind being undertaken, and their focus was on farming. The Jeromes purchased, or they sold rather, to the federal government a grassland preservation easement in 2015 with the intent that the remaining land would be preserved as open space or for agricultural uses. Mr. Jerome said his parents never intended to run or expand a commercial quarrying business, and again, that the removal of rocks and fill had been from a very small part of the land. He further outlines that, as he is a nearby resident, that the quarrying activity by Highland Farms has affected his quality of life for the worse. He discusses noise pollution, dust from screening loam right next to his house, increased sediment in the water, and concerns about the effect on our well water. There's been evidence submitted by David Rickerby, who resides on April Lane in the near vicinity of the property. And in addition to his complaints that the noise and activity associated with the property have interfered with his ability to work and enjoy his home, he's provided a series of color aerial photographs over the years that reveal no excavation or quarrying activities on the property. And contrary to the suggestion of Highland Farms, one doesn't need to have a degree or to see that there's greenery there and not rock ledge. These photos rebut the suggestion that there was excavation or quarrying activities on this property. The photos rebut the suggestion that the land was used continuously as a quarry. And of interest in his discovery that the Jeromes applied and received farmland classification for their property, which the land use for commercial soil, gravel, stone, and other materials are not eligible for inclusion in this program. Land classified as farmland must be actively devoted to agricultural or horticultural uses. In 2019, Mr. Chase formed Highland Ridge Farm, LLC, and described in a 2020 filing, described to the public that he was in the business of farming operations, hay crops, forestry operations, logging, per his annual report filed with the Office of Secretary of State. There is a lot in these materials that show that no intent to expand this quarry, and that there was land removal activity going on in the years since Highland Farms has purchased the land or owned the land. There's no question that there's been significant intensification and expansion of activities with heavy equipment, drilling, banging, noise, heavy traffic that its neighbors have been adversely affected, including potentially threatening wells and water supplies. The materials submitted by the abutters raise a substantial issue about abandonment, intent on the part of the Jeromes, and the adverse effect this expansion has had on the property. I don't think that conclusion. I'm making that finding as dicta and not basing my motion on that. But I would move to affirm the 5 cease and desist orders because our Supreme Court has upheld the fact in Carty that zoning boards can require some type of control over mining, earth removal, and by extension, quarrying, and that the public interest and the health, safety, and welfare of our community deserves to be protected. And I make the motion that we uphold
I second the motion.
each of the 5 dated March 22nd, 2023.
I second the motion for all of them.
All those in favor? It's unanimous. Thank you.
Just for the record, I believe now that we'll be filing a written decision, which will begin your appeal period.
Thank you for that, Mr. Solicitor, and thank you for your time, Madam Chair, members of the board.
I just want to remind you on behalf of the town that now that this board has made a decision, I do believe that the statute does impose an automatic stay on any future activity on that site.
Understood. Thank you.
Thank you.
Thank you.